Gentlemen, we warmly welcome you back to Day 2 of Learning from Our Neighbours Conference 2025, organized by the Human Rights Committee of the Bar Association of Sri Lanka. So, yesterday we reflected deeply on the role of the judiciary, the challenges of extremism, and the courage of lawyers defending rights during people's movements. And today we continue these meaningful discussions with equally important themes on strengthening justice, protecting freedoms, and empowering human rights activism. So, to begin today, we have panel 4 on the importance of strengthening lawyers of first instance court. And our speakers will be Honorable Dibanas Fahmy, Justice of the High Court of Maldives, and Mr. Colin Gonsalves, Senior Advocate of the Supreme Court of India and Human Rights Law Network. The session will be moderated by Mr. Mahbooba Rifaideen, Attorney at Law, Sri Lanka. I warmly invite Ms. Dibanas Fahmy, Honorable Dibanas Fahmy, and Mr. Colin Gonsalves on stage. And ladies and gentlemen, let us give a round of applause and welcome them on stage. I hand over the moderator to lead the session. Over to you.
So, very good morning to you all. Today we are reaching panel 4. So this morning, our title for panel 4 is The Importance of Strengthening Lawyers of First Instance Courts. We have two distinguished panelists here. First, Honorable Dibanas Fahmy, Justice of High Court of Maldives. Justice Dibanas Fahmy has been serving on the High Court since 2022. With 17 years experience of the criminal justice system, she made history in 2020 as the first female judge appointed to the Criminal Court of Maldives. Before joining the bench, she served as Deputy Prosecutor and LLM Hons from the International Islamic University of Malaysia, and LLM from the University of Canberra, New Zealand. Our second panelist is Colin Gonsalves, Senior Advocate of the Supreme Court of India. Mr. Colin Gonsalves is a Senior Advocate of the Supreme Court of India and founder of the Human Rights Law Network, a pioneering organization in public interest litigation. Over more than 3 decades, he has specialized in human rights, labor law, and constitutional litigations, securing landmark judgment on the protest rights, custodial torture, government accountability, and economic, social, and cultural rights. Widely regarded as one of India's foremost public interest lawyers, he has argued several precedent-setting cases that advance protection for marginalized and vulnerable groups. In recognition of his tireless advocacy, he was awarded the 2017 Rights Livelihood Award for his innovative use of law to secure fundamental rights. Madam Fahmy, the floor is yours.
Thank you again for giving me an opportunity to speak here. And as we are slightly behind time, I'll just dive right into the issue. Our topic today is on the importance of strengthening lawyers of first instance courts. First of all, it's the first instance courts where you lay down the foundation of any case, irrespective of whether it is a fundamental rights case or even any civil matter. And most of the time, unless you have a good foundation, it's not going to do much even if you go on appeal. And that's always the case, and everyone knows that. What I would like for you to think about is how does our way of thinking as lawyers change the entire idea and application of law when it comes to the same provision being reinterpreted. For an example, let's take theft. Theft will have the old concept of theft would usually entail taking a person's physical property without the knowledge of another, dishonest appropriation and all of those things. But in today's age, it does not have to be something physical, for instance. It can be digital. It could be something that is not tangible. There are many ways of committing it, but we still use the same provision. What I'm trying to say is that what we really need in interpretation of law is innovativeness that needs to come and start at the first stage, at the trial stage. And that comes most of the time by way of different ideas and different backgrounds coming together. My main concern when it comes to this, in our context, in the Maldivian context, is that, to give you a bit of background again, we didn't have a law college or a law school up until 2000. And we didn't have an LLB offered in the country up until 2005. I myself am the first to graduate from a small law faculty, and at that time they only had a diploma awarded. Most of us who gained a law degree gained it from outside the country, which meant that we had people who held degrees from other countries, not always from common law jurisdiction, civil law, common law, all of this. Graduates from Azhar, graduates from UK, graduates from Malaysia, Singapore. The application of law in those countries and the way that they do it, the entire system, made our current system not what it is, not just homogeneous in its application. It gave us all creativity. But however, with new law faculties being established here, established in the Maldives currently, what we are now seeing is a stagnation when it comes to legal thought. You have one idea and you do not have that creativity. And the main concern when it comes to this is that it is always creative application of law that will have to start off a different idea and a better environment for creating rights. A good example yesterday was mentioned by Madam Hina when she said that doctrine of basic structure, I'm still thinking about it. She made me rethink the idea from a different perspective, something that I had thought would not change at all for a really long time. But I've been thinking about it at the back of my mind all day and yesterday. And that different perspective is how we could bring about change and how we could make the first instance courts, the lawyers who attend the first instance courts, to come up with more creative ideas. And that's just one example. So I'll just leave you with that for now and hand over to Colin to speak.
Well, last night and early this morning, I looked at my notes. And when I read the notes, I was a little bit, to put it mildly, dissatisfied with the notes that I had made and the points that perhaps I would have presented. It was as if time had stood still, and the notes that I made 10 years ago, 5 years ago, and so on, I would use again and talk of the sort of good work that our organization had done. But I was deeply dissatisfied with that, particularly after listening to the stories of the uprising in Nepal and the uprising in Sri Lanka and the uprising in Bangladesh. Thank you for calling me here today, I must say, from the bottom of my heart. Thank you for calling me, because you have given me a chance to regain my original vision of looking at the world. And even though we are under attack, not to only think about the attackers in their immediate proximity to the people of India, but to look at the world and see where it is going, so that when we think of educating our young lawyers, as we used to do, we would teach them how to do criminal law, women's law, housing rights, refugee rights, environmental law, the whole gamut of NGO thinking. It's good. NGO is not bad. But NGO thinking is now a little bit outdated. And times have changed. Times have changed drastically. And there is something more to it in the education of young lawyers and the training of young lawyers, which we must keep in mind. What caused us to lose our registration and have our bank accounts frozen, which eventually turned out to be a strengthening point for us. We were remorseful in the beginning when we couldn't pay a salary from the day the order of suspension came. We were worried people couldn't look after their families. We had 175 young lawyers, which is quite a big network, really. And from day one, when in 2002, February, that order came, we couldn't pay the salaries for the next month. And now looking back at it after so many years, I realize it was something that gave us muscle, it gave us strength, and it gave us mental courage to say, all right, they can't lock our tongues, they can't lock our brains, they can lock our bank accounts. So let's do with what we have, the richness of what we have, and let's do that, and teach in a different way the young lawyers of India. I lost it because of the Manipur fake encounter case. And the fake encounter case was one which was going on for decades in Manipur. The army and the commandos of the police executed people in cold blood, 300 a year, relentlessly, year after year after year. And different attempts to take this case to the Supreme Court or even to the High Court were rebuffed. Lost the case, and every time we said, let's do it again, the common refrain would be, you've lost once, you've lost twice, how can you try it a third time? But when we did it this time, it came before a panel of judges who were remarkable. And they appointed immediately a committee of a Supreme Court judge and 2 other High Court judges. And the Chief Election Commissioner at that time. And they looked at the material because the court told us, we want to be sure that what you're saying is true and not just some storytelling. We want them to get a prima facie view of the case. And these 3 persons went to Manipur and made a remarkable report saying, this case of fake encounter is absolutely genuine. None of the persons killed were terrorists from any terrorist organization, and it was a pure and simple case of extrajudicial execution. And I remember one case where a young boy was reading to his grandmother the newspapers because she couldn't read, her eyes were weak. And he was sitting in the morning and reading to his grandmother when the police came in and asked, who's Akbar? And shot him dead. I mean, the Indian situation is really a never-ending situation of terror. Took him out to the garden and shot him dead. And they wrote that Akbar wasn't a terrorist. And Akbar was pure and simple a case of mistaken identity. And these cases deserve to be. So then they were investigated by a special team. And it was also an extraordinary order, and this is what we have to teach our young people. extraordinary approaches for extraordinary times. A different way of thinking, particularly when you have lost so many times. Don't get into the same rut of thinking and drafting petitions and arguing in court. And the second is, don't think that merely because you've lost the case once or lost the case twice that you don't do it now. You cannot let the demoralization which seeps into society seep into a young lawyer's mind. The young lawyer must be foolishly, terribly foolish in his eternal optimism to fight against injustice, knowing that he's on the right track, she's on the right track, and that sometime, justice will prevail. So we kept at it. And in the end, the court had said, no investigation by the police, by the local police of Manipur. Because if the police are executing, you can't have the investigating team consisting of the Manipur police, and ordered officers from outside the state to investigate the extrajudicial executions. And then we had charge sheet after charge sheet being filed. And I remember meeting the top brass of the army when they came. They were very perturbed by this development, that the Supreme Court had all of a sudden, having rejected similar attempts so many times in the past, they were taking it up. And outside the court, I would talk to these generals. I noticed they were very high-ranking officers of the army, perturbed by what had happened. And I went to them and told them outside the court, and this was a very important conversation. I said, sir, general, sir, this has nothing to do, sir, with your army. It has nothing to do. Why should you get involved in all this, sir? You know the reasons for the killings. It has nothing to do with insurgency. You know, you picked them up from home and you took them from in front of their parents. They were sleeping and you took them and these guys went and shot them dead. Why should the army get involved, sir? I beseech you, at the highest level of the army, persuade them that this is not the task for the army to do at all, to get involved in all this cover-up of these things. So we won that case, but we won the case outside the court, even better. Because from 300 a year extrajudicial executions in one state of India, it dropped to 3 today. Today there are about 3 or 4 or 5 or 6, and all genuine encounters where the underground groups open fire against the army and they retaliate and kill you. But that cost me my registration and my right to take funding and so on and so forth, which I think is a small price to pay for those orders which cover extrajudicial executions throughout the country. It's used as a model for extrajudicial killings throughout the country. What is the remedy? What is the solution? What is the court order that you ask for? Because if you ask for investigation to be done, the same police investigate their brothers and sisters who opened fire in the first place, then that's not a solution at all. And the second example I want to give, and this is for teaching young lawyers, is Chhattisgarh, where the Home Minister, Mr. Amit Shah, gave orders ostensibly for the killing of the Naxalites, the Maoists. And then we found, because we work closely with some of those sections, Sori is the name to remember. So she called and said, they're killing ordinary people. They're just going into the village and killing ordinary people. And she sent me some videos. And now it was dangerous to go to Bastar. But we took a team and we took a judge with us. That is again another strategy that to use with the... We took a retired judge who came with us and we took videos of the testimony of 100 women. And it's on the website of the PUCL, India. You can see that, that video. 100 women coming with their babies in arms and giving testimony before me and the retired judge. You know how they were at home and how suddenly the army came in and they all put their hands up and their houses were searched and their village was searched. So obviously they are not Maoists. There are no weapons at all. And you can see, and they are minors from 11 years, 12 years. They put their hands up and they opened fire and killed them. The barbarism of that kind is not associated with India. It's supposed to be a vibrant democracy and all that. And that Chhattisgarh thing came also, and so now my fate was sealed in the sense that I'll never get any permission from this government anymore. But like I said, it's a small price to pay for what we do. I used to do trainings. We had 175 lawyers. 175 lawyers, and we did trainings across the country. I was blessed with funds. Some people in the funding agency loved what we did and liked whatever. I was blessed with funds, and it's a lesson to be learned. So we did training after training in a month, 1, 2, 3 training, going across the country, covering all the states, teaching everything from disability law to LGBTQI rights to criminal law to everything. But now we cannot do that anymore. And there's a lesson in the learning. Times have changed. And the inspiring events of Bangladesh, particularly Sri Lanka and Nepal, the inspiring events of people dissatisfied with government for years, fed up, angry, frustrated, wanting to do something and not knowing what to do. This is not just, these 3 countries. This is across the world. The world is on fire. And the young people are restless. Many give up, many surrender, many keep quiet, many have confusion in their minds, many lack the self-confidence. But the world is on fire. And in this period when the world is on fire, what is it we should tell the young lawyers and the social activists to do? We always put them together. We never had purely legal meetings. It was always law and social activism, because the social activists are better trainers than lawyers are, generally. They're superb trainers because they combine life experiences and the struggle on the ground, and they have also, I've seen that always, social activists in any branch of law have a better understanding of law than lawyers have. Lawyers have a school bookish kind of attitude. No matter what you do with them, you can't change them, because 5 years in law schools damages their brains. But the lawyers are unfettered, as the lawyer in the last session with me yesterday. Unfettered. Their language is different, their heart is different, it beats differently, their feelings are different, their articulation is different, and they are inspiring. That is the thing. So now, keeping this in mind, our trainings have to switch a little bit, not entirely, from the technical training aspects of law, to inculcate movement in our trainings, and to teach young lawyers to be political right from the beginning. From day one of the trainings, political approach. And a political approach means not a political party approach necessarily, it is a movement and struggle approach. And to be more precise, it is an uprising approach. You must be in sync with, you must be in tune with. Even the young lawyer who comes must be in tune with uprising. In my country, you use the word azadi, freedom, and you go to jail. You use the word revolution, you go to jail. Khalid, who is the symbol of resistance in our country, provocative speech, and he went to jail for 5 years. I use the term total revolution. Not yet gone to jail. But I use that term, total revolution, because it was used by Jaiprakash Narayan against Indira Gandhi. Sampurna Kranti. So if Jaiprakash can do it and he's like a a leader, an accepted leader by everybody as a leader of people. I use that term, and it's a very volatile term, complete revolution. No in-between kind of nonsense, complete revolution. And then we have to take our young lawyers. The only way to open their minds and educate them and get out of formal education, not entirely, but in a major shift, take them to the combat zones. You must take a lawyer if you can get a judge, but I can't get judges anymore. Retired judges always tell me, we're in arbitration today. So retired judges have lost the fiery spirit that they used to have earlier, and take them to the combat zones. So in Chhattisgarh, we take them to the combat zones, sit and listen to the testimonies. This is an area where the government said, you cannot go there. There is armed struggle taking place. We are shooting people. We cannot guarantee your safety and tell them, thank you, sir. Thank you very much. Try if you can, but thank you, sir. It will be my fault. If I'm injured or shot or whatever, I will not blame you at all. Please let me go, and we go. Nothing is more terrible in India than the fate of Muslims. I especially want to emphasize this. If you're a Muslim and a Kashmiri, you will never get bail. No matter what the facts are. If you are a Muslim and a Kashmiri, you will never get bail. And I'm doing the case of Shabir Shah, a lion of a man. 32 years in jail with 17 FIRs against him, first information reports against him. Never convicted. Never, no allegation that he ever picked up a gun or he threw a bomb. 32 years in jail. And the only reason is he had a nice, brave way of speaking to the people. His only fault is he spoke about the agony of the people of Kashmir. That's all. Did he incite revolution? No. Did he tell people to take to violence? No. He just spoke about the anguish. The anguish in the heart of Kashmiri Muslims. Their suffering and pain. He met 3 prime ministers in public. Can you imagine a person accused of terrorism? And I file it all before the Supreme Court. This is the man that 3 prime ministers met him and asked him to find a solution to Kashmir. And there are photographs and so on, and TV, it comes on TV. What kind of terrorism is this? And he's in jail, Shabir Shah, 30 years. If you're a Muslim and you're living in Islam, your home will be demolished. The rest of the homes will stand. If you're a Muslim and a Rohingya, despite the fact that the Supreme Court judgments say Rohingyas have fundamental rights under our right to life clause, not just people who are citizens have fundamental rights, anyone residing within the territory of the have the right to life. Therefore, you can't push them back. You push them back and they get killed there. They run from a genocidal state and you push them back into the genocidal state. Covered by Supreme Court judgments. But you're a Muslim and you're a Rohingya, you'll be sent back. To hell with the court. To hell with the court. That's virtually what the law officers say. And that's exactly what the court listens to quietly and calmly and ignores the argument. Then India, Pakistan. I'll just say a few words about this. India, Pakistan is supposed to be a problem that can't be solved. It's not India, Pakistan at all. Indians love Pakistani people. Many don't because of the hate speech of Modi. But many do. And Muslim people love Indian people. Same culture, same food, same volatility, same integrity, same language. And after Pahalgam, when the attack took place on tourists in India, in Kashmir, Who ran to the assistance of the people who were killed? Who ran to their aid? It was the ordinary Muslim of Kashmir, the rickshaw puller, the handcart puller, the shopkeeper ran, documented well now, ran to their assistance, spent money on them because they had lost their purse or whatever, spent money of them, took them to the hospital, took them to their hotels. No finest example, no finer example than the ordinary Muslims of Kashmir, without them being told to do so, risking their lives for people they did not know. Because the Muslims of Kashmir have a very fine understanding of injustice and love for people. So I don't allow anyone to talk India, Pakistan. I said, sir, you recognize this first and understand how fine the Muslims are of Kashmir are. So I want to just end by saying, for young people today, apart from their usual stuff that they learn about statutes and how to implement, and the little finesse that you need in the Supreme Court and the High Court, teach them to be courageous. And once they learn that little finesse, which is easy to learn the courage of presenting a case no matter what the judge says, and be fully prepared. If the other side is half prepared or not prepared, don't take consolation in that, and be fully prepared. Be an expert in what you say and what you do. We have to work doubly hard as compared to the other side. And I'll end with the example of the farmers' struggle. All our young lawyers joined the farmers' struggle. 1.5 years through the biting rain in winter, with the police waiting with their bulldozers to shift them. The farmers of Punjab and the farmers of India stood firm. Struggle is the norm. The environment is an environment of relentless struggle, continuous oppression and relentless struggle against oppression. Stood firm. And when we set up a tent inside we got permission to set up a tent inside the struggle point, where we stayed in the night and so on. And you can see, you can physically, feel the rising anger in the veins of the people of India. Young, daredevils, bold, outspoken, full of laughter and humor, deriding the government. What a lovely thing. What a lovely thing to experience. I suppose all of you who've been through these uprisings have seen it also, but we have our mini uprisings, and we saw it in the farmers' struggle. And Mr. Modi had to surrender. He had brought out certain farm laws that were very anti-farmer. He had to surrender. No better education for a day one lawyer than to throw them into the deep sea and say, learn to swim. Throw them in. And they will come back with such enthusiasm and spirit, they will not leave. Some will, but many will not leave the path of resistance. Thank you very much.
Thank you, sir. Thank you, madam, for these very grateful insights. So this is the time for questions. Dear participants, if there are any questions, please raise. So, sir, I have a question to you.
Yes.
So, you said that the NGO thinking is outdated. Then how the legal aid lawyers can play their role to protect the rights of vulnerable community Because for me, NGO thinking lawyers do legal aid more.
I'm sorry, madam. I think it's my fault. I didn't explain what I meant.
Yeah.
See, NGO thinking is you're given an agenda, or you make an agenda for yourself. You look for funds from abroad or wherever, you collect that money, and then you do legal aid for the poor, right? It's not a bad thing. I'm not saying it's something that should be or can be jettisoned, just forget it. You can't make a transition from NGO thinking to movement lawyering, to struggle lawyering. You can't just jump. It'll come slowly. It took me many years, but it takes others also many years to go and make the transition. But you must train people right from the beginning that the agenda is not teaching people what the law says only. Okay, in criminal law, this is the section, this is the provision, this is how it is used. That's not our main task today. When I started, it was the main task. When I started for 10, 20 years, I did that as the main task. It's an important task. But I'm little overemphasizing a new side, which is today the main task is slightly different. That you must do. Teach the law, teach the tricks, all that kind of thing you must do. But if you don't get the movement part, everything else is lost. They turn off your funds, what will you do? Where is your capacity to organize and resist? Or, like in India, they just ignore court orders. Never before done. They will ignore the court order completely. Prosecute this army person, do this, do that. They will ignore you right till the Supreme Court of India. So see, ma'am, what happens is, what will you do then? So then you merge. I think that a time will come when you are ready. You've got the armor, you've got the resilience, you've got the muscle, you've got the determination, you have the courage to be part of what is happening. That is what we have to train young lawyers for. Be part of what is coming. And I must thank you, Sri Lankan Bar Association and my friends, for calling me. Because for me it has been such a tremendous learning and such joy to talk to people who have gone through Bangladesh, 10 years in jail, Sri Lanka, I don't know, Nepal, look at what's happening. To talk to you all about your struggles, learn from you, and prepare for India. Largest democracy in world. Largest democracy. When that shudders, this part of the world at least will also shudder, rightly or wrongly, in a good way or a bad way. So it teaches me today how to prepare for that, and I go back and say, and I thank you also, but I also want you to do what you're doing on a slightly bigger scale in South Asia. Now do it on a regular basis, choose a safe country to do it and do it. But I must exhort you, now that you are free from your jails, work to free others from their jails. That only you can do. We cannot play that role, but only you can do that. I want to just say, please do it quickly. We are running out of time. Please do it quickly. Do it extensively across this region. I hope I answered your question, ma'am. Yeah, somewhere.
Thank you.
Yeah.
So we can have time one questions from the audience. We can open. Yes, sir.
Death row inmates on whose behalf I made applications, because under the Sri Lankan state policy, they are not given presidential pardons like the other prisoners, because they claim there is no written law There is no written policy. They claim that there is a state policy not to pardon the drug offenders. And this application was filed in 2018. It was just kept away, just ordering the respondents to look into it, including the Commissioner General of Prisons and the Minister of Justice and the Attorney General. Nothing happened. I made another motion last month, and again no order. Again I was explained that, as we have told you before, there is a state policy. But to date, even from that moment onwards, I am looking for this so-called state policy. There's nothing written anywhere. So this is an unwritten state policy. I'm just giving you the example so that it will be easier for you to answer me. Just tell us how you employ this particular tactic of going back to the same court again and again. Thank you.
Yeah. Sir, the Supreme Court of India is not a single Supreme Court. We have 17 Supreme Courts of India sitting in a circle of courts. And every judge on that court thinks in a different way. You come before court number 7, you get bail. You come before court number 8, it is rejected. And people on death row were traditionally refused. Very often they would hang. Like in Afzal Guru's case, if you're a Kashmiri and you're a Muslim, you will hang. Many others. But the same case, in the case of 17 persons who were on death row for 5 years, simple case, that it is cruel, inhuman, and degrading to keep a person sentenced to death on death row with a sword hanging over him for 4 years and more, 3 years and more without execution. A cruel argument to make, really. That once you pass that 3-year limit or 2-year limit, keeping them in solitary confinement, it is cruel, inhuman, and degrading, and the death sentence must go. And look at that case. That case was in respect of the killing of Rajiv Gandhi in a bomb that killed him and injured at least about 8 or 9 or 10 people who were around him. The former Prime Minister of India, look at that case. No better case than that. And we came before the Chief Justice of India, then Satashivam. Things are said about him. But I love that man, the way he dealt with this case. So it's the chance of the dice. He heard us at night. It was 7 o'clock at night. It was raining. They were to be executed 8 o'clock in the morning. And we got to know from jail that they are cleaning the gallows. So a journalist said, sir, they are cleaning the gallows and they've offered the prisoners non-veg and given them a clean set of clothes to wear. We rushed to the court. Lovely man. No matter what is said. Sir, we want to meet from 5 o'clock in the evening till 11 o'clock at night. I thought we were doomed. And he called us in at 11. In the rain, we were standing with our umbrellas. We were annoyed that at least he can give us a place where we can stand outside the rain. He called us in. And he called us in with a smile on his face. So, Colin, what's happening? And in that, Colin, what's happening? My whole body relaxed. My blood pressure went down, my heartbeat became normal, because that communicated something. He sat with us. He already had read the papers. He knew what he wanted to do. He called his assistants and dictated the order. These persons have been in jail for 5 to 7 years. This is not acceptable, constitutionally wrong, and I stay with the hanging. Can you imagine? After having rejections, and former Prime Minister, the cliched argument was, sir, he killed the former Prime Minister. He deserves to hang. And not only that, he sat with us then for 2 more hours, 3 more hours, till about 2 o'clock or 3 o'clock in the morning, and told his staff, none of us will move from here until we phone the jail superintendents and make sure that they will not do the execution tomorrow. He didn't want a mistake to happen. So, sir, my answer is, when you have your back to the wall, when you have no chances, no alternatives, be daring, don't listen to anybody's advice. Don't follow any rule, any regulation. You have to do it like this. Any procedural niceties are not to be followed. And you will have surprising results. You're on the path to justice, you'll have surprising results. Go again and again and again. Like the Manipur case that I told you of, the fake encounter case, so many times it was tried. Take the right to food case, which is recognized as a very important case in the world, where we got food through a constitutional court to an extra 300 million people through the judgments of the Supreme Court. Before we went, it stood at about 150 million subsidized grain. When the case was over, it was something like 400 million. And today it stands at 800 million free grain. Can you imagine? It's a court pushed, court driven, huge economic right against hunger. 3 times before then, people went to court with the same statistics. Levels of poverty, levels of malnutrition, levels of hunger, stunting of children, anemia for women, all data from India and abroad. Rejected, make representation to the authorities. And we went back again and we came before a Chief Justice who was not known for his human rights thing. Kirpal. I said, oh my God, Kirpal. I was a young lawyer then. I went before the court. Kirpal opened his papers. My heart was thumping. He opened his papers. And then he looked up at me. I was a new lawyer, so he didn't even know who I was. And he said, this cannot be. And I thought to myself, what is he saying? Is he saying that this petition cannot be, or what? He said, Mr. Gonsalves, you amend this petition, make all the states parties. We cannot allow a situation like this in our country. So a completely conservative judge gave an order which set the ball rolling to make a historic case on economic rights. So never fear, sir. The struggle of your spirit now can never be overcome. Nobody can touch us. They can try. They may win also sometime.
Lawyers when they are practicing in courts, and what are your suggestions that lawyers should improve in their quality as practicing in first instance courts?
Thank you for the question. I suppose I keep saying this. I've only been on the other side of the bench.
Especially, defending human rights
Yes.
cases.
For a very short period of time. And I can honestly say, please don't quote me on this, but I can honestly say that there have been many an instance, even at lower court and at high court, where I wish that I could jump down and then start arguing on behalf of the accused even. And that's a reality. And that reality is partially due to a lack of education, and like I said before, a lack of creativity too when it comes to application of law. I believe that a lot of young lawyers, and it's not because they're young, it's probably because of our way of education system. They do not allow us to think. They allow us to conform to what has already been prescribed. We see a huge amount of case law that's going to go against what is being asked by the client as a right. As a right, for instance, just like again, Madam Hina said, right to life has always been identified as the right to be alive. Just that, without death. But that quality of life aspect was not something that was thought of before. And one of the things that I have come across, and something that I actually miss now because I do not have the time to teach anymore, is that it may sound naive to us at first, but their way of looking at the law when they first hear it, they see it without any prejudice, without any additional ideas, without any encumbrances of theories of what ought to be. They come up with original ideas as to what it should be, what we want. When a client comes to you, they come because of a grievance that they feel emotionally and not always expressed through proper legal language. But they feel that a wrong has been committed. And that wrong, that sense of injustice is where the right begins. And it is not always an identified right. But I feel that when a client comes, we should, as lawyers, try to find exactly why it upsets them. Find out why. Ask more questions. It may not always fill in that neat little box that has already been identified, already been recognized as a point of law. It may be a new and nuanced and fragment, a new approach towards an idea of a right. But they come because they find that there is a sense of injustice in what is being done to them. Try to argue from their perspective as lawyers, try to find a way to put that thought, that feeling across the same judge. You may come across, and I would say that this happens often enough. Judges often tend to see things through a very narrow lens, unfortunately. But once you put it before them, a new idea, and you persistently push for it, they don't have the option, they often don't have the option of not looking at it. Make sure that they do actually not just dismiss it. Come up with a way that it may not always be something that is clear, something that is going to be against what most of the policy, what's not going to be very popular as a policy. And most of the time, rights do not entail things that are popular. Rights are not popular. And just like Mr. Collins said, it takes a lot of courage to do that, and it takes a lot of creativity too. And I think that part of how we present may not always be strict legal theory. And I know that as lawyers, sometimes emotions do not, we try to stay away from emotion, but sometimes that theory coupled with that emotion actually brings about the story of a person and an individual, how they feel and their sense of justice far better across to the judge. And they may actually be inclined towards giving a judgment in your favor at times, even with that emotion. And I would say that, again, I'm sure that there are a number of members of the bar, but we see here today a very small number, and that's always going to be the situation. That's always going to be the situation across the world, everywhere. Even in the Maldives, we have about a little over 1,000 registered lawyers. out of which 700 or 500 actively practicing, out of which only 40 would go to court, and out of that 40, only about 10 would actually work like you would in advocating for rights and be constantly in that struggle. It's a thankless job, yes, but like you said yesterday, and it resonated with me a lot. We do it for a very selfish reason. We all do it for a very selfish reason, which is a sense of satisfaction we get. We don't do it for fame. We don't do it for thanks. We don't do it for money, for sure. Most of the time when it comes to rights, it's always pro bono. And we do it for a sense of satisfaction, that sense of justice that we had when we first went to law school. That first day of law school, or that day we made that decision to become lawyers. It is that fulfillment that we keep looking for. And when you go and present your case, I say you look for that in the judge also. You look for that emotion, invoke that, aim for it in that judge, and make them rethink all the stagnant thoughts that they've had for years, decades even, and make them write a judgment that's diverse, that is more courageous than what they have written. Give them that opportunity. Make it so that they do not have any other choice other than doing just that. And I'd say that in my just short 5 years as a judge, the one that gave me the most satisfaction was a dissent that I gave 2 months back. A short dissent on an application made by a woman whose right to register a marriage was denied, and it was based on a decision that was in contravention of all fundamental rights of equality to law. And when I wrote that judgment, I was the chair of that bench, and the way it works is that we, as the chair usually writes, the presiding judge writes, and the others comment. I actually had one additional judge on the bench who wished to agree with me, but she wanted one sentence removed, which was my sentence saying that the family court had erred, and the family court the actions of family court was in violation of equality of right before the law. That was the only reason why I wrote it. And they wanted it removed. And I said, I'm totally fine with whatever you think. You're most welcome to write a different judgment. I'm not changing that sentence. And I'm certain that come another 10 years, someone will definitely agree with that. And I think that it's not always that perfect decision where you have 3 agreeing with you, but that dissent will give courage to other lawyers who would use that as a persuasive authority, someone who could bring up a different argument which may actually hold water, or actually make a difference, enough to make a difference at some point in time. So I think that to answer your question, to say it simplistically, don't lose heart. It's not going to be easy, and it's never going to end. This is a constant struggle. It's always going to be upstream. Everything, all the resources of every country is going to be stacked against you, but still you work. You make headway. You move a little bit forward, and yes, you'll slide back too. But don't lose heart and always have that courage to move on and keep struggling. Thank you.
So now we close panel 4. My sincere thanks to our panelists for your great insights, and thank you for participants. We close panel 4.
Once again, I take this opportunity to thank Honorable Debanas Fahmy and Mr. Colin Gonsalves for this insightful discussion. I'm sure all of us were inspired by listening to their personal experiences and their perspectives. Let's give them a round of applause once again and thank them. Also, I have a kind reminder to all of you. As Mr. Lakshan shared yesterday, day 2 today we will end today with a mentoring session, and the organizers have kept a board outside with the names of our panelists. And if you wish to be mentored by one of them, please feel free to write your name and paste it under the particular mentor that you would like to be mentored. With that note, we will now break for tea break. Please be here by 11:15 so that we can conclude with the next sessions. Maybe you can write your name and paste it under the particular mentor along your way to tea. Thank you. I hope all of you are ready for panel discussion 5. And the topic for panel 5 is protecting the freedom of expression and assembly in South Asia. Our distinguished panelists are Miss Hina Jilani, lawyer at the Supreme Court of Pakistan and member of the Elders; Honorable Hari Prasad Puyal, Justice of Supreme Court of Nepal; and Mr. Anik Haq, Advocate of the Supreme Court of Bangladesh. And this session will be moderated by Mr. Viranjana Herath, Attorney at Law, Sri Lanka. I now cordially invite Mr. Viranjana Herath and the distinguished panelists on stage. Let us give a round of applause and welcome them on stage.
I think I can still say good morning. Good morning to you all. It's my privilege to moderate such a wonderful panel. I'm not going to, make any descriptions, many more introductions about distinguished panelists, but I have to say, Ms. Hina Jilani, without your name, I think women's rights of Pakistan, justice to the women. Apart of that, I can say that name of the women in the judicial system, human rights, women's rights in Pakistan cannot be mentioned. So she's the founder of the first women leading law firm in Pakistan. Also is one of the founders of the Human Rights Commission of Pakistan. Ma'am, welcome you for the panel. And then Justice Hari Prasad Puyal. It is honor to be with you here, sir. Then later I got to know about that we were in alumni of National Law School of India University for the master's degrees. Very proud to be here with you. Is the judge from Supreme Court of Nepal and so many research area, is a legal expert and also made several books, several publications, especially the human rights and the commercial law both. That is the basic introduction I have to give about him. Then finally, Mr. Anik Haq, Advocate of the Supreme Court of Bangladesh, with the expertise and experience of not only the judicial system and the court perspectives, also with the research and the consultation with the World Bank and some other organizations. So again, I welcome you all. Now, the topic is protecting the freedom of expression and assembly of South Asia. Today morning, one of my US colleague, Professor Eric Robinson, sent me a message. It says that, his article actually, what he said that in First Amendment of the US Constitution say, the Congress shall not make any law against the freedom of speech and expression. But what he argued, except the Congress, all other institutions of the US now make laws against free expression, from the president to the below level, low level. What he wanted to say, share the experience with me, this is our way, we are the so-called First Amendment free speech people, but this is the reality of us. So why then, as South Asians, we all know where we are now today. From morning I was here, then recently we have experienced so many uprisings. And in one time, because some years back and from the beginning, I also used to say social media platform, online platforms are one of the most weapon with us to take up our free expression, to utilize our right of free expression against these authoritative regimes. We are saying like that. But in the meantime, now we have to say that who are the people controlling by the social media platforms? The tech giants are not going to deal with some small countries of South Asia. They also become, Mr. Colin Gonsalves know about that. They are ready to regulate in India, but they are not ready with our 3 countries. Even they are not dealing with us. So where we are now? Not only for the freedom of speech and expression, for freedom of the assembly is now, it's kind of an online platform thing. It's become an online platform thing. In Sri Lanka, we experience what we exercise our freedom of assembly through the online platforms. This is we are now. So without taking any more the introduction, I'm going to invite, first of all, Ms. Hina Jilani to your first round of thoughts. Then we will go for the questions after your basic thoughts.
Thank you very much. People like me and other human rights defenders are more passionate about the freedom of expression and assembly because the promotion of human rights and the protection of human rights cannot be continued and sustained without these 2 freedoms in particular. Having said that, I think in South Asia in particular, the human rights defenders, and particularly the media, have been hit very strongly and adversely by the restrictions that are imposed on the freedom of assembly and on the freedom of expression. Let me also remind you that neither the freedom of assembly nor the freedom of expression are absolute rights and are amenable to restrictions. So what we have to see in our legal context is what restrictions can be termed as reasonable. Standing on this side of a courtroom, opposite the bench, are ideas of what is reasonable and the ideas that judges may have of what is reasonable are many times very different. Legislation that imposes restrictions on the freedom of assembly and on the freedom of expression usually repress expression when it concerns criticism of governmental actions, or, and I know that in Bangladesh, one of the human rights defenders had to suffer a great deal. He runs an organization called Odhikar because of a report that he had published, reporting violations of human rights. And this has happened to many people in Pakistan as well. Journalists have been particular targets of repressive legislation where restrictions have been placed which are totally unreasonable and repress the spirit of the fundamental right to the freedom of expression. It is also important to understand that restrictions are said to be reasonable under international law only where the government can show that there is a necessity for such restriction, there is proportionality in imposing those restrictions, and that, above all, these are restrictions that are in consonance with the values of democracy. The International Covenant on Civil and Political Rights makes this very clear. Restrictions that can be imposed to preserve and promote the democratic order, rather than restrictions that in any way impose a kind of repression on the freedom of expression. So these are the important issues that we deal with. So the whole question is, how do we evaluate the restrictions regime, the limitations regime? Anything or everything from the point of view of a government can be reasonable if it is in any way connected to questioning and challenging issues of governance, issues of respect for human rights, and adherence to the rule of law. This is the difficulty that we as lawyers and human rights defenders are grappling with in most of the South Asian countries. On the freedom of assembly, I think the freedom of assembly gains much more significance in the context of human rights when it is seen as the right to protest. Freedom of assembly is not a freedom to exercise the right to assembly, but to exercise the right to peaceful assembly. As the special representative of the UN Secretary General on Human Rights Defenders, I had the opportunity in the 8 years that I was implementing that mandate to look at issues in almost every country in the world, almost. And I found that where this violation of the right to assembly had occurred and the burden had been placed on the people who were organizing the assembly, it was a peaceful assembly, and the response that the government and the security forces gave to such an assembly changed peaceful assemblies into riots. So there is a responsibility not just on those who are holding the assembly to keep it peaceful, but also on the methods that the government applies in order to deal with peaceful assemblies. And the kind of brutality that I encountered in many cases, that the police or the paramilitary or the military forces exercised on the people who were protesting, it was of a level where one can say that though that kind of brutality can be very credibly called torture. So with the freedom of assembly, the response of the government also has to be evaluated, and many times it is a combined effect, disproportionality as well as torture occurring during freedom of assembly. The other thing I want to say about the freedom of assembly, and I'm limiting my comments on this, and I hope that more can be said during the question and answer. Another important issue about the freedom of assembly is both the freedom of expression and freedom of assembly are a part of what is not usually written in Constitution as a fundamental right, but is inherent in the right of the citizens to participate in governance. The right to protest usually is a right that is associated with public visibility of the protest. And therefore, designation of certain areas outside of public view for holding a peaceful assembly are denial of peaceful assembly and the right to protest. Protest is visible only where it is assured that the public has access and the public is able to see that a protest is going on. Many of these restrictions on the freedom of assembly or the freedom of expression we associate with colonization of some of our countries. In Pakistan Penal Code, we have a notorious Section 144. I'm sure India has that too, and Sri Lanka and Bangladesh, where the government can at will invoke that section to bar public access to those places, to make sure that assembly cannot be held in designated areas, to make sure that certain kinds of political gatherings or speeches cannot be made. And this article has been used now, even after the colonization period has ended. So let us say, do we blame the colonizers when we keep continuing the same practices that happened during colonization? Of course, the intention of the colonizers was to control. Are we living now in the current era in the same kind of environment which was imposed on us by colonizers? That is true, we are living in that. But have we made progress? Some of the more recent laws that have come into being in Pakistan, for instance, are extremely repressive of the freedom of expression. You cannot imagine how much freedom of online expression is now being repressed through laws that, like Pakistan Electronic Crimes Act, for instance. And this is hitting human rights defenders and journalists much more, because the wording of the law is very loose, very ambiguous, and anything can be taken as a crime committed electronically because you have said something. But also, another issue in Pakistan is the laws concerning offenses against religion. And primarily, it is what words you utter that can be criminalized under the blasphemy laws. So there are many issues here where academics have been indicted under blasphemy laws for teaching something that the more conservative interpretations of religion do not accept. So any alternative views are also designated as blasphemous. So there is that added burden for you to observe silence rather than be criminalized. We have, at the international level, the Human Rights Committee of the United Nations has said time and again that the laws of libel should not be criminalized, and a civil liability should be sufficient. In Pakistan, we do criminalize cases of defamation, and you can be indicted under criminal laws for that particular thing. And I think that these two pillars of the defense of human rights have become one of the most attacked freedoms in many of our countries. Of course, there are people who are still protesting. There are people who are still using their freedom of expression. And like many of us are saying, it's not the question of freedom of expression. The question really is freedom after expression. What happens then? And that is the consequence that we keep dealing with, rather than energizing ourselves more and more in challenging those restrictions and clarifying through our practices as lawyers, but also through our advocacy as human rights defenders, what can be a reasonable restriction and what cannot be a reasonable restriction in a democratic order.
Thank you, ma'am. This is the issue with us also, where we are going to restrict the pre-expression. What is the limits? This is the issue with us. We have so many disproportionate approaches followed in Sri Lanka also. I can give examples, but this is not the time. Thank you for your insightful initial remarks. Now I would like to invite Justice Hari Prasad to explain your initiate thoughts.
Thank you so much, dear panelists, moderator, and respected audience. Now, I will try my best to, as brief as possible. It is like almost 85 years that we have a modern judiciary in Nepal. So the regime kept on changing in the difficult situation. So the courts, however, remains from its beginning very conscious on the freedom of expression and right to assembly. We can find very old judgments of before 80 years where, like freedom of speech, how court gives interpretation even without, before the UDHR or before the, other human rights instruments. Freedom of expression and freedom of protest is recognized by those old judgments. And during the Panchayat time, that was one of the regime which ran actually for 30 years, we had a difficult time on freedom of expression and assembly. That was a one-party system. Even in that time, court was positive on giving expression, especially on the print media at that time, and press, because the state used to seize the press and even the published paper. So when there was a protest in 1990, the constitution was more liberal, and freedom of association, freedom of assembly, and freedom of expressions were written in a very liberal framework. Though they are not completely, free, there are certain regulations, and these regulations are written. These are the exceptions where restrictions can only be imposed by the law passed by the parliament. Let me make it very clear, not by any regulations or guidelines, passed by the act of parliament. So after, then we had a second appraisal. This one is the third. Second appraisal, of the people. Then king was in power. So he prohibited, or he banned all internet, press, printing of the everything, almost for 6 months. So then he is gone. So new constitution was drafted. So now constitution provides 3, provisions. One is the preamble. It says that there shall be complete freedom of speech, like complete changes, complete freedom of speech in the preamble. The word complete is very important. It goes to the fullest level, so restrictions should be minimal. And we have another article, which is 17. It says that right to freedom of expression and right to freedom of assembly, are provided conditioned to the following restrictions. Then we have a separate article called Article 19, which says right to communication. Right to communication. Right to communications mean it includes press, it includes, press and print media, online media, or any electronic media, or, information or communication in any form shall not be restricted, provided on certain conditions, national security, sovereignty, hate, race, these kind of things. And that all has to be restricted only by the act of the parliament. So these are the constitutional provisions. I would say that in contemporary South Asian countries, our constitution is, since recently written, provides the highest standard of, constitutional provision. And actually on freedom of expression and assembly, on the 2024 Global Index, out of 160 countries, we rank 74. In Asia, we rank 5. In South Asia, we rank 1. We are the freest country, actually. In the latest, actually, protest, if you look at, there was only social media ban. They were trying to regulate them. Supreme Court said them, please have a law passed by the parliament first. But they came with guidelines. And that guidelines was quite not acceptable. So, what they should have done, should have taken the bill to the parliament, passed it. But they did not go directly to that line. They had some problem with the international social media and they tried to regulate them. So, and that, backfired everything, one of the triggering, factor. So, in the context of Nepal, I think, still, whosoever want to protest, they have to go and register in the district administration office, give their contact. The security forces, especially police provides some, protection to lead them where to go and where not to go. They provides the area. Or if there are competing, protests, assembly, they will dedicate different places to the different groups. On freedom of expressions, the Supreme Court repeatedly has said that we provide the freedom of expression to the fullest level and we follow the principle of proportionality. Every cases cannot come in a contempt of court. We distinguish what is contempt of court. If I have done something at my personal level, and if I'm criticized for that, that's not a contempt of court. For example, we have a judicial council. They appoints the judges. If judicial council is criticized for appointing the judges, and chief justice is involved there, we don't take that as a contempt of court. That is a different act. Contempt of court has to be particularly judicial and direct and indirect attack, physical or written kind of attack. So we distinguish and we look at to the threat and proportionality. And in some cases, we simply say that this is a case of slander. You have a district court to go. In Hindi, we call it gali bejati, right? So they go to the different district court. So we are very open to the criticism of the judgments, even to some extent to the behavior of that particular judge. We do not seal a particular behavior of the judge by the contempt of court. And leaders are openly criticized. There is no restrictions. And the more problem of the leader was the deep fake and deep fake and what you call malinformations, not only from the country, from cross border, abroad, originated in other countries and used against them. They were so worried of that, and they tried to regulate, but not from a different way, and they They were not, the international social media did not comply on that. So I think, so that will remain even in the coming change. Freedom of expression and freedom of movement or assembly, everything will be intact. There will be no restrictions and no changes. Rather, it increases. And society is getting more tolerant, like you have to be tuned or ready to accept the criticism, even sometime more than criticism, like, negative criticism. Since you are in a public post, you would be criticized for doing something small wrongs or sometimes doing something good, and we expect that these criticisms are quite okay in a open society. So our stand from the court's point of view is that we provide fullest, and government always try their best, leaders not to be criticized, not to be attacked by these kind of things, like international or national kind of social media kind of things. So I don't have much to say. Court is progressive on that area. So still, however, sometime what court has to be restrained is that in social media scam or in this kind of slander kind of cases, who would be the victims? Are the high profile people. They come to the court and they file a petition. They says that my personality is ruined, so look, they have to pay this much of compensation. We judge in Nepal, we provide a special training. Be careful. You look at your profile, the profile of your victim. If that person is being criticized by social media, do not act hastily. Wait. Perhaps you can ask that person to go to the administrative, remedy. For example, we have a cyber bureau. You go to cyber bureau, talk to them, request them to remove. But still, case will be there. But we ask also, you go and file, and we see, what result comes. Or we order them, why don't you remove that person's this thing and report to us? So, we apply restraint on looking into the high-profile contempt cases, and so that is what we call is politically sensitive cases, where if you are protecting one particular victim, which is a high profile, but it backfires in the society. So this is the lesson that we have taken, and we apply that restraint method. However, finally, I would say that any restrictions should be proportional, legitimate, and by the act of the law, and that has to be followed, the principle of rule of law. I think this is the basic. And the also is, look at, I do not have any opinion, but look at to the role of social media and our democracy. How social media is impacting on our democracy, on our choice of political parties, our choice of administration. And I don't know whether they should be regulated by a sovereign nation or not. We have a sovereign walls. Should there be internet sovereign wall or not? That I don't know. How far they kept on influencing to the domestic, affairs. Should there be a gateway permissions? Should there be a registration? Should there be an official regulation? Should there be a market like advertisement control? Should these things should comply or not? That I don't know much, but these are the lessons that we need to talk in South Asian context. Thank you so much.
Thank you, Justice Sari Prasad. It was wonderful. Actually, you are the very right person to explain about the freedom of speech and expression and the contempt of court, because except all of us, because you are a justice from the Supreme Court of Nepal, because I think we are in limited while speaking in that that kind of things. But thank you for pointing out that issue also. Whatever the, we always discussing about that thing in here in Sri Lanka also, what is the limit of the free expression and the contempt of courts. Also, the very insightful thoughts about the disinformation and how we don't know about actually, that is the answer, we don't know how to regulate the social media, to what extent, to how what is the way. It's the questions. It's very good. Thank you. Thank you very much for your insightful thoughts. And then now I would like to invite Barrister Anik Haq, Advocate of the Supreme Court of Bangladesh, to make your initial remarks.
Thank you. Just unlike Pakistan and more like Nepal, Bangladesh Constitution provides specifically for freedom of assembly and freedom of expression under Article 37 and 39, but these are not complete freedom. These are qualified freedoms with reasonable restriction, as ma'am has put very kindly that what could be reasonable and what would be not. I am not going into that debate. I am going to talk about how we tackled our situation back in Bangladesh. Before advent of internet, we had the penal code provisions of section 499 and section 500, which deals with defamation. That is still there. But when internet and online publication and social media came into being a big thing, then the Bangladesh government enacted a law called Information Communication Technology Act. This act was supposed to come out in 2002, but it was actually enacted in 2006. There, unbeknownst to any of the draftsmen, they inserted a particular section, section 54, just as dreaded section 54 as CRPC as this was. There, the language was very loose, that if somebody posts something online which hurts someone's feelings, that will be an offense. So my first thought was that my ex-girlfriend, if she puts out good morning to the world, my feelings is hurt. Can I sue her? So basically the point was this, that the whole thing was termed in such a way that each and everything could fall under that. So what did we do as lawyers? We challenged it before the High Court that this law is ultra-virus of the Constitution because it takes away my freedom of speech, freedom of expression. Interestingly, the court rejected our case, saying that this is a law which has been passed by the elected representatives of the people, so this cannot be unconstitutional. Very interesting argument from the court. Against that, we filed an appeal to the appellate division, that is the Supreme Court, and one of our actual point was that even a democratically elected representative body of the people can act no less oppressively than an authoritarian state, and that is exactly what has been done there. Thankfully, while this case was going on, the government said that they are scrapping this law and they're making a new one which will be more citizen-friendly. So we waited. What they did, there were, in section 57, there was feelings of someone, religious sentiment, cheating somebody, everything in one section. They, in the new act, which was called the Digital Security Act, divided each component into each section. So basically, in section 57 of the previous act, there were 7 offenses together. In the new act, they have created 7 different offenses. Again, we challenged that before the court. That case is still pending. But in the meantime, August 24 happened. The people rebelled and the previous regime was uprooted. One of the things that we did when, again, I hope it will never be treated as abuse of my power, when I was made the additional attorney general, one of the points that we made that we want all these sections to be gone, to be erased. And an ordinance is passed just about 2 weeks back, where all these sections where your online postings can be curtailed we have deleted that. We said, you are free, but you can be free, but you are not free from your conscience. You have to use your conscience. Please don't do anything. This is basically a request to, which we put out, that don't do anything which might incite racial hatred, religious hatred. Don't do that. Basically, Bangladesh is not that religiously inflammable people. They're rather tolerant. So that has been done there. And the best thing that we did, that the cases that has been filed under all these sections, we just brought them all under one umbrella and said that these were all malicious prosecutions and these are dismissed. So as ma'am was saying, that Mr. Adilur Rahman Khan, who was the chairman of Odhikar, was actually jailed for publishing a report. And now, ma'am, you will be happy to know that he is now one of the ministers of the country after the post-revolution. So along with him, we agreed on this point, and we said that, no, we are not going to put people in jail just because they have a difference of opinion than ours. They can post whatever they like, and as Justice Fuller has said, that there is deep fake and malicious, misinformation going on around. We are actually leaving it on the goodness of the people to understand that it is upon them to uphold their own freedom. Because we believe that freedom is a very fragile thing. It's not made out of granite. And unless the people, general people, take interest in the public affairs, the chances of that freedom surviving is very slim. So we are actually asking the people that use your own conscience, use your own judgment, and then you post it. Of course, there's going to be abuse, but we are going to see about that. But at least we are not going to jail anyone for posting their opinion from now on, hopefully. I don't know whatever the elected government will do, but while we are there, this is not going to happen. And as for the contempt of court, the line is very thin, because in Bangladesh there is no statutory offense of contempt of court. It comes out of the common law practices and all that. There is this old 1920 Act which does provide that if somebody says or do something which demeans the estimation of the court in the eye of public, that is there. But just because one particular editor published an editorial saying that the government has not actually done something good, 2 journalists filed contempt of court against that particular editor. And he fought the case up to the appellate division, and very interestingly, which we never saw, during the initial stage of hearing, that editor was arrested and put behind bars. And those 2 journalists, one was basically a court journalist, that is, he was a lawyer as well. As a reward, he was made a justice of the High Court. So one thing again we are now trying to introduce is that the contempt of court cannot be actually filed by individual people. They can come and bring it to the notice of the court. If the court then thinks the action or the words that has been said does offend them, does affront them, only then they will issue the rule, I say, that is show cause and all that. Earlier it was sort of like I can go and just file a case and insist on an order. Now it is basically no case that to be filed. It is upon the judges to decide whether they have been insulted or not, or with seeking pardon from 2 justices over here, whether they have been insulted enough or not. Right, like if you remember that Lord Denning in his court, somebody threw a shoe while he was sitting, and he said, I think the argument was so boring that this was there, I am not insulted, it's go on. So it basically again depends on person to person, how thick the skin is and all that. But one thing again we have done, we have ensured that by words of mouth, there cannot be any contempt of court. If you write something, if that is being sort of like distributed, then there, but while you were inside the court, at the heat of the moment, you may say something. The courts of our country, they have decided that no, this is not going to be held as contempt of court. Thank you.
Thank you very much. Your insightful thoughts. I love that part, that no one should be jailed based on the expression.
Yes.
It's a kind of a motto to us as defenders of free speech and expression. I think it's a very good, especially during this time. So thank you again for your insightful thoughts. Now I would like to open the floor to you people, my colleagues, to raise your questions, raise your thoughts. I think now it's the time for that one. We still have time. You can raise your questions, please.
Since there are no questions, can I put in an additional word here?
Sure, definitely.
I think Justice Hariprasad Puyal has very clearly outlined the whole question of what are the restrictions that would be reasonable and accepted as such by the courts. Now, of course, in all our constitution, restrictions have to be imposed by law in the first place. The problem for us is that then we have to challenge those laws, because many of those laws are not in consonance with democratic traditions. And we have to make courts understand and accept what is reasonable and what is not reasonable, even in that context, when they're imposed by law. Another thing, I don't know whether it's the same in other constitutions, public order, to maintain public order, and then morality. That is a very broad range and variety, what would be moral in somebody's, from somebody's point of view and not from another point of view. So these are some of the things that become difficult when the Constitution allows restrictions on certain grounds, which become, which are so relative in many ways, that the understanding of what is morality is very different. Then, of course, the sovereignty, integrity, etc. of the state. You are all the time, the human rights defenders are questioning the security laws, public safety laws, official secret acts laws. Even our Army Act has in it many things which are restrictive of the freedoms, particularly of civilian, when the Army Act should not apply to civilians at all. So these are many examples of challenges that we have in persuading courts that what is written in the law is not necessarily a reasonable restriction. The other thing I would like to point out is, there is, in 1998, the United Nations adopted the Declaration on Human Rights Defenders. And that declaration has looked at the freedoms, fundamental freedoms, from the point of view of the defense of human rights, where the freedom of association, the freedom of assembly, the freedom of expression have a special place. And that's why I say that many of us as human rights defenders, whether we are lawyers or not, have a special passion for these laws. I remember the days of martial law in Pakistan. The problem for us as human rights defenders at that time is with regard to education, public education, more awareness amongst the public of what are human rights and what is the respect for human rights. Because we don't have the freedom of movement, we don't have the freedom of assembly and the freedom of expression to be able to have that access to public visibility that we need in order to perform our primary function, which is to disseminate the ideas on human rights and educate the public enough so that we are not only eradicating practices of the state or attacking practices of the state, but also of the society, where they are committing human rights violations every day in the domestic sphere, in terms of the more marginalized communities, the minorities. And in Pakistan, although we do have laws of hate speech, et cetera, but we don't have a single example of where hate speech against another religion than Muslims has been the source of some criminal case. On the other hand, we have several cases, more than 700 at the moment, filed against non-Muslims for saying something which somebody amongst the Muslim community thinks is a hate speech. So these are some of the things we have to grapple with at all levels. It's not just the state, but also the society that needs to be educated, and for that, public visibility and the ability to disseminate human rights standards is important.
Thank you, ma'am. Yes, sure.
I think this is just to add on Hina's point. Look at the security laws of your country. We have come after 1948 to ICCPR and other human rights standard. We have higher constitutional standard, but most of the South Asian countries have colonial times security laws. We were not colonized, but the impact of the colony is there. So therefore, the modern standards of the handling mass assembly, or like in the case of Nepal, how to use the force, where to shoot people, what is the proportionality, what are the measures are to be taken, are they still old one? They are not revised. Whereas the constitutional standard and the international standard we have ratified are much, much higher. So I think we need to encourage the parliament to look into those security laws. And the other laws that restricts freedom of expression, if they're quite old-fashioned, has a colonial impact, they need to be brought into the modern human rights and constitutional standard. This is just the point. And other in social media, I think we need to be very conscious using education. Education is very powerful to dissemination among the youth and others, how to use social media, what are the impact, and how to make them more beneficial. We cannot avoid it. Now the age of AI is coming. We cannot be afraid how AI works or in our context. But people need to be educated. What are the impact it is going to create? So these are such a powerful tool that changes the existing entanglement or connections of our society. So the other is, the important thing is diplomacy on social media. Look at the powerful countries, and most of the social media's origination is there. I think they need to be persuaded through the diplomatic methods. They need to be persuaded, to have access at least to the gateway. And if something is, terrible that can cause a lot of problem in a country here, should have access to that particular, company to delete or remove, those kind of context. And the third, South Asia should contribute on handling of social media, some basic norms. I don't know, there could be a UN forum, there could be something for how to handle social media, the regulation, norms from human rights perspectives, how to handle artificial intelligence from human rights perspectives. So that causes the balance between the security and freedom of expressions. Thank you so much.
Thank you. Sure, Anik.
Hina ma'am, this will be of interest to you. In Bangladesh Constitution, with the freedom of speech, the usual decency, morality, and contempt of court, defamation, these are included. But a very interesting restriction is there, that friendly relations with foreign states, we cannot say anything which might jeopardize friendly relation with foreign states. Now, thank God that Israel is not a very with Bangladesh. Otherwise, I would have been in jail now, again.
The United States is.
That's why I always say that Trump is great, in whichever way you take it.
I must say, it is in the Indian Constitution too, that kind of a section. Yeah, yeah, they have. Nepal also? Yes. Yes. So, still we have 5 minutes time. If you have any questions, you can raise it. If you don't have a question, I have one question. I can raise it. Yeah, please. I have one question, sir, for 2 minutes time. We have 2-3 minutes. Yeah, sure. Please.
South Asian countries, the freedom of expression of the minority is suppressed by the majority. So how we overcome that kind of, how we protect that right? Now here we experience it in Sri Lanka. It is nothing to do with the law or the government or anything. The majoritarian pressure not let them express their view about their problems or their grievances. My question is to the whole panel.
I think the situation in Pakistan can be a good example of that, or a good example of how the rights of minorities to express their grievances that the majority suppresses by instilling fear in particular. And I think that is something that we are also not able to take to court because it's not that kind of tangible legal question that you can pose in the courts of law. But at the same time, if the Constitution was adhered to, it would be an inherent right of the freedom of expression of all citizens that the minorities also enjoy. The problem in our countries mostly is that the majority views either are shared by those who are in authority to do that, and therefore there is complete impunity. Or the state itself fears the voice of the majority and therefore neglects or ignores the voice of the minority. And therefore, it becomes an added challenge and drives many of the human rights defenders to the streets rather than to the courts of law. And here, when minority issues are concerned, where there is no legislation to impose any obligation on anyone not to say something, then we have to go to the streets rather than to the courts to make sure that the majority understands that these are obligations that every human being has, and not just the obligation of the state to observe human rights.
In Nepal context, from court perspective, like there was an issue in one of the LGBTI case of freedom of expression. Freedom of expression means like, a transgender person wears a transgender kind of clothes and goes around, and police abuses that person. And we said in the court, like, that person has a freedom of expression and the way he or she prefers. That's a minority community and it's a personal freedom. So they should not be arrested because of the dress they wear, and they, do not look like male and female. They fall under the, different, what we call as a third gender by then. Now we call it sexual and gender minority constitutionally. Otherwise, in our context, sometime when minority protests come out, the case is not in the court. There are some criticism like minorities are threatening the social harmony or racial hatred. So this kind of criticism I have heard, but there is no particular case. But I think from court perspective, if a case comes, if lawyer brings the cases, court's standards should be look at to the from proportional freedom of expression and proportionality basis. Is there any real threat created by that, or they are just expressing their freedom of expression, or it just annoys the ruling parties or government administrative things? If it is annoying, no one is expected to be in a comfortable zone. People can be in an uncomfortable zone, but that has to be a real danger of hate speech, racial disharmony. So you have to calculate the threat created by that particular action, which we call is proportionality, and the action done. I think that should be the court approach. Thank you.
In Bangladesh, the minority basically is the religious minorities, the Hindus. And one thing I'm just asking you all, that is, don't believe the Indian press when it comes to the oppression of Hindus in Bangladesh. Don't. After 5th of August, when there was this sort of like riot going on, the Islamic leaders, they actually arranged patrols to save the Hindu houses so that no one can take the chance to do so. In Indian media, 22 cases were reported. Only 2 were actually racially aggravated riots. The rest was 2 families fighting amongst each other, but that was treated like that. So what did we do, or what are we trying to do is, this is something which cannot be settled through the court, what I believe. So we are driving an awareness program amongst the Hindus that you guys also have the same rights that the Muslims do. And the Muslims, we are trying to just quote them from the Quran that you are supposed to take care of your neighbor, irrespective of whatever religious belief they hold. So this is something which we are doing, and I'm very proud to say that last year, around this time, when there was the Durga Puja, the biggest Hindu festival in our area, in our region, not one, usually there were, before there were the deities, they used to break it, vandalized and all that. Last year, not a single incident like that happened, because we gave the duty to each and everyone that you are going to protect your neighbor. Don't let them come to any harm. And that is being done, but yes, it is going to take some time to have complete harmony, because in every country there are fanatics, but we are trying to bring them down by creating awareness. I don't think that is something which a court can order that no Hindu shall be attacked. I don't think that is going to work. So that is how we are going to tackle it. Thank you.
Can you give me 1 minute to say something very positive about our Supreme Court? This has nothing to do with freedom of assembly or expression of minorities, but in terms of protection of minorities. In 2014, a judge of the Supreme Court rendered a judgment after certain incidents of violence against certain minorities had erupted in different parts of the country. So he was taking up the issue of not just violence, but discrimination, the right to equality, right to equal opportunity. And he rendered a judgment in which he gave 14 directions to the government, saying this is what they have to do in order to make sure that the minorities are protected in all their rights. And the good thing is, he just didn't give directives. He formed a monitoring bench of the Supreme Court to continuously monitor. I'm, of course, appearing before that bench on behalf of the Human Rights Commission. So these are some of the things that Justice Fahmy was talking about. Being innovative and creative, not just as lawyers, but also as judges. And that monitoring bench is now monitoring what the government has actually done in terms of impunity for violence against minorities, in terms of giving them opportunities that are consonant with their population. So these are some of the things that judges can do. And these can be used by human rights defenders in order to monitor the situation through the courts.
Thank you. I think we are running out of our time. So thank you very much to all of three distinguished panelists. It's a wonderful discussion. I would like to conclude the session like whatever we discussed lastly. The court can do so many things. Also, court cannot do everything in the sense of protecting fundamental rights and the human rights. Though we are lawyers, we have to accept the facts. We have to get the justice to the people. I would like to end the session with this thought with you. Thank you very much.
Once again, I would like to thank our distinguished panelists for shedding light on the vital freedoms that remain the cornerstone of democracy. And before we move on to our final panel discussion, I take this moment to invite Mr. Lakshan Dias on stage for a brief moment. I'm sure all of us here present today were blessed by our distinguished guests here. And as the Bar Association Human Rights Committee, we take this moment to appreciate our panelists, our distinguished speakers. And I would like to invite all of them on stage. Ms. Hina Jilani, lawyer at the Court of Pakistan and member of the Elders, I invite you on stage. Honorable Hari Prasad Puyal, Justice of the Supreme Court of Nepal. Mr. Anik Haq, Advocate of the Supreme Court of Bangladesh. Honorable Dibanas Fahmy, Justice of the High Court of Maldives. And Mr. Colin Gonsalves, Senior Advocate of the Supreme Court of India and founder of the Human Rights Law Network. I invite all of you all on stage now. Let us give them a round of applause, ladies and gentlemen.
Ladies and gentlemen, friends, on behalf of the Human Rights Committee of the Bar Association, now we would like to present a small appreciation gift to remember this event for our distinguished guests. And I'd like to invite
Thank you, Mr. Lakshan Dias. So this will be our final panel discussion for the day. And panel 6 focuses on challenges and strategies in human rights activism, protecting freedoms in a changing world. And the panelists for this panel discussion will be Mr. Suren D. Pereira, Attorney at Law, Managing Partner of the Human Rights Law Chamber, Sri Lanka, and Ms. Swastika Arulingam, Attorney at Law, Human Rights Activist and Convener of the Human Rights Committee, Bar Association of Sri Lanka. And also I would like to invite the moderator for this panel discussion, Mr. Lakshan Dias, Attorney at Law, and a strong human rights defender on stage. Let us give a round of applause and welcome the panelists on stage.
It's my pleasure to invite or introduce these two colleagues, friends, and fellow human rights activists and lawyers. I don't have a formal presentation on Swastika. Swastika is also the convener of the Human Rights Subcommittee Committee of the Bar Association, and Suren also member of the Human Rights Committee of the Bar Association. More than that, these two are prominent lawyers when it comes to the human rights. And for them, we don't need any introduction. Their deeds, their work is giving enough. And Swastika is a lawyer, and also she, in her work, she has, mark her presence or done cases on almost every aspect of human rights. And also she's a very strong activist on gender, on the minority rights, and the workers' rights, and almost all every. So, I have no formal way of introducing my friend Swastika. So, by her presentation, we will get to know her more. And also same with Suren. Suren has a very formal education on area of human rights. He's having a master's on human rights, as well as he's running a chamber on particularly on human rights, as well as he's working with a lot of human rights organizations in relation to the awareness raising and on human rights law, and doing public interest litigation on human rights. So these two young lawyers are the future of the human rights work of Sri Lanka. So I would like to invite Swastika first to do her presentation, and then I would like to invite Suren. And then we can go for question and answers.
Since this is the last session, I thought, and because this event was also organized by many young, not only lawyers, but also law students, I thought I'm supposed to speak about freedoms, right? But I thought, where do freedoms start? It's as the previous panelist was saying, freedom is not, it's not given, it's not written on concrete. It's something which is very fragile, and it has to be protected. So in terms of this session, the last 1.5 days, 2 days, and so on, we have been discussing several ideas, not only in Sri Lanka, but also from our esteemed panelists from across South Asia. So, drawing from those ideas, what do we do in the coming years? What do we do, particularly as law students as well as lawyers? What do we do in terms of human rights? So, I thought of the fight for rights and freedoms at different levels. We have to fight for our rights as lawyers because we think we are very privileged, but there are many things which happen inside the courthouses, outside the courthouses for lawyers, and do we actually speak about that? Then a fight for a more inclusive judiciary. There are things which happen inside courthouses. Do we actually speak about those openly? Then of course, how do we see ourselves as partners in social struggles, whether it be struggles like the Aragalia, whether it be farmer struggles, worker struggles, women's struggles. These are struggles which do not have, particularly in Sri Lanka, we don't have enough lawyers standing in solidarity with these struggles. So I want to speak about that as well. I'll start with lawyers. When we come to lawyers, we think, we are protected, all of our rights. We are a privileged group, and indeed we are a privileged group in society. But certain things which happen inside courthouses, do we actually critically look at them? I'll start off with someone like myself, a lawyer from the minority community. In the courthouses, one of the first challenges I face is language. I am a Tamil-speaking lawyer, and how many courthouses in the south actually provide proper translations for not only litigants, but also for lawyers? So every time we walk into the courthouse, we have to almost request for it. It's not given as of right. We have to request for it. It causes a lot of uncertainty, it causes a lot of embarrassment. So how many lawyers actually speak of the language rights of minority lawyers in this country? Similarly, women. I can count in my hand the number of female counsels who actually stand before court and make submissions. On an ordinary day, if you go to the Supreme Court or the Court of Appeal, in the first two benches, very rarely you will see a female counsel, unless the counsel is from the Attorney General's department. So, do we actually think about why women do not come into active practice? The usual examples which are told is women are not interested. If they're married, the husbands don't allow them to practice. I don't agree with any of that. Women have children, so they don't have, so men also have children, no? But they are before court. So I don't agree with any of those arguments. What I do want all of you to think about is that if women are struggling after getting married, if women are struggling after bearing children, then what is the duty of the profession to help women overcome that struggle, so more and more women come into the courthouses? So as professionals, as lawyers practicing in court and as active professionals, I want us to think about our profession and whether we have been facilitating rights inside our own profession. And junior counsels, the payment given to junior counsels are never spoken about. So our junior counsels, are we supposed to, now I'm not considered junior, but when I was a junior, are we supposed to live on? Yeah, we also eat, we also have expenses. So these are things which we don't speak about because we think we are a privileged profession. And what we were told by our seniors is like, no, you grit your teeth and wait and then you have your time. But why should we grit our teeth and wait, We also come into the profession to earn. So these are things which I want particularly young lawyers to think about and start speaking about it. We have done a bit of work, but we have a very long way to go. And I think you also have to take up the mantle and speak about it. The second issue is the judiciary. Yesterday I had the privilege of listening to Justice Fawmi and Justice Puyal. And some of the things which they were saying in terms of facilitating litigants, opening up the court spaces for marginalized groups of people, but also persons who are economically vulnerable. These are some things, in our courthouses also this happens. I've come across several magistrates who have facilitated, for instance, who have facilitated clients who do not have lawyers, and they have actively found lawyers for those litigants and so on. So we also have those experiences in our judiciary. But today I want to speak about an issue which is considered almost taboo in our legal profession, which is judicial bullying. Judicial bullying happens in our courthouses, maybe not so often, but it does happen. And when it does happen, how do we tell, particularly for junior counsels, how do we tell them to deal with it? We tell them to deal with it by, no, don't speak about it. Because if you speak about it, then they will crush your practice. That's how I was told, right? And several other junior counsels also are told the same thing. But judiciary is a very important pillar in our democracy. If you look at our constitution, so you have the executive, you have the legislature, you have the judiciary, and the judiciary or the parliament through the judiciary exercises judicial rights of the people. So when the judge sits on the bench, he is not exercising his inherent powers. He is exercising the powers of the people. So when the judiciary decides to exploit that power or abuse that power because of the fact that they are sitting in a higher table or whatever, then how do we as lawyers speak about it? How do we as lawyers speak about judicial bullying? I don't have an answer to that question because that is a taboo subject and we don't speak about it. But I wanted to, in every single presentation which is given to me, or this opportunity which is given to me in the bar, I do want to speak about it because particularly female lawyers, this is the other taboo subject, female lawyers go through harassment, female lawyers go through sexual harassment, both in the profession and outside the profession, both in the profession as well as from clients, and we don't really speak about it. And that also can be a reason why women don't stay on in this practice. So that is also another topic which we don't speak about. So I'm raising these are considered very controversial topics, but I'm raising these issues today because these are reasons why our profession is not expanding or not becoming inclusive beyond a certain point. Courts are still considered, how many litigants can actually go to the Supreme Court? How many litigants can actually take a fundamental rights application and go to the Supreme Court? Last year, a man was beaten to death in a police station in Jaffna. Why hasn't that case still come to the Supreme Court as a fundamental rights application? So these are things which we as lawyers have to critically think about. I don't have answers to these questions all the time, or most of the time, but I want all of us who are sitting here, because obviously all of us are interested in human rights, to think about these questions, come together and think about these questions. The other issue which I want to speak about is, I was talking about how the Supreme Court can be more inclusive. One of the aspects, one of the issues we learned from our neighboring country, India, is how the Supreme Court accepted letters from prisoners and how they adjudicated on those letters, considering those letters as petitions, and they heard a fundamental rights application. And we did have that system in Sri Lanka many years ago, I think under Justice Shirani Bandaranaike, where when the Chief Justice receives a letter, she would send that letter to the Legal Aid Commission, and the Legal Aid Commission would convert that to a petition, and then the fundamental rights application is heard. I don't think that system exists anymore, correct me if I'm wrong, but I think we as lawyers have to start talking to the judiciary, start talking to the profession to make our profession more inclusive. Not everyone can come, write petitions, write affidavits, write petitions and affidavits in English and come to the Supreme Court in a country where majority of the people are not English speaking. So these are strategies which we should think about as lawyers. Yesterday, we were speaking about how lawyers are the backbone of a society. I would like to speak about that. I would like to say that in every social struggle, whether it be farmers' struggle, whether it be workers' struggle, whether it be the Aragalia, I would not see us as a backbone, but I see the legal profession as a very important element of supportive element. We are also part of this country, we are also citizens of this country. We have a very important role to play in terms of strengthening that struggle, in terms of our solidarity towards that struggle. I'll give an example. Last year, the government of Sri Lanka brought an act, a horrendous piece of legislation, legitimizing certain institutions in terms of providing microfinance. Now in this country, if any of you are aware of the microfinance situation in this country, there are suicides. Women commit suicides because microfinance companies come and harass women, sexually harass women to collect debt. So we have suicides in this country because of microfinance. Women, farmers commit suicide all the time. So when this piece of legislation was brought in, for the first time, I believe, correct me if I'm wrong, for the first time in the Supreme Court, I saw, in my last 10, 11 years of practice, I saw the front rows of the Supreme Court filled with female counsels. Because female counsels were actively getting involved in supporting women to fight microfinance cases. So even the judiciary was shocked to see so many female counsels in the courthouse for the first time, like even in my practice. So that is a very and then we managed to stop the legislation. So that is a very important step in terms of or an example how lawyers can support struggles when it comes to important struggles. And the other example, of course, is the Aragalia, when more than 40 persons were tortured and put into jail for simply asking the president, why don't you give us electricity? I think nearly 400 lawyers turned up in the courthouses to appear pro bono for those 40 persons who were arrested. So that's like a very, very good example of how lawyers stepped in to support a struggle when the country was rising against economic oppression. But similarly, there are several other struggles which we don't have enough lawyers to support, because in struggles, as I think Lakshan and Suren will attest to it, we don't make much money out of it. You know, it's completely we are on our own. We don't make any money out of it. So it's not a financially lucrative thing to, you know, stand in solidarity with struggles. But just to give an example, because it comes from a very personal experience, I work with I'm part of a trade union. And one of the things which workers in this country constantly face is the violation of freedom of association. The Sri Lankan constitution says you have a right to form and join a trade union, but almost every day in the free trade zones of this country, workers are dismissed from work for forming and joining trade unions. Today, the plantation sector, plantation workers are also denied the right to form and join trade unions due to various political reasons, but they also denied the right to form and join trade unions. And that is just one example in terms of rights violation when it comes to workers. So how do we as lawyers support trade unions? How do we as lawyers support workers' movement? Another example, there is a labor law reform which is coming in this country, completely removing every single protection which workers in this country and across the world have fought for the last century, because the International Monetary Fund dictates that we need to have this labor law reform. So are we aware of it? Are we supporting workers to challenge this labor law reform which is brought forward by this government? So these are some things which I hope going forward we will think about and get actively involved in terms of our struggles. And finally, yesterday, Mr. Gonzalez was talking about a regional network of lawyers. Now, I have always been, beyond having conferences and meetings and sharing experience, I was always a bit, I never had any idea as to what a regional network of lawyers can do in terms of strengthening a struggle. Because for me, ultimately, whatever we do, it has to be strengthening, it has to be supportive of human rights struggles which are going on in the ground. And then recently, we came across two examples where we did not have enough support, and I wished we had a regional coalition of lawyers. Two things. One is the debt situation. Sri Lanka went into a bankruptcy a few years ago, and the common topic is that, common consensus is that we have come out of a financial crisis and now everything is good, you know, in this country. But nearly a third of our Sri Lankan population are not eating. If you look at statistics, nearly a third of the Sri Lankan population are below the poverty line, right? In a country where you literally can grow food across the country, 1/3 of Sri Lankan population do not eat in this country. And the reason for that is debt. We are not out of, we may be out of bankruptcy, but we are not out of this debt crisis. And how is our government dealing with this debt issue? Is they are using the pension funds of workers to set aside the local debt. Now, not many lawyers are speaking about it in this country, but what is interesting is that the debt issue is not only affecting Sri Lanka. It's not a local problem. 56 other countries have the same issue across the region. While we were negotiating terms with the IMF, Bangladesh was also going through a debt issue, right? So it's a regional problem. It's a South Asian problem. It's a third world problem, or a global South problem. And when this issue was going on, we were trying to form a coalition, a debt coalition, so that we can together fight against this debt problem. And there were other activists and other social actors coming together, but we could not find many lawyers. So then I thought of what Mr. Gonzalez was speaking about, is that if we did have a regional network of lawyers, would we not be able to support something as powerful as a third world network of countries against ODS debt, is something which I was thinking about. And the other aspect is something which is happening right now. There's a genocide which is happening in Gaza, in Palestine. And as the third world, we have by and large not been able to do anything. And the strange thing is that when Palestine was first established, I mean, now as a state, I mean, Palestine was always there, but as a state, when they declared themselves as a state, one of the first countries to recognize Palestine as a sovereign state was Sri Lanka, right? We were one of the first countries, and we did not just do that. We said we don't want the Israeli embassy here. We will establish a Palestinian embassy in Sri Lanka, but we will not recognize, we will not give any kind of status to Israel in this country. That is the kind of political position which took back in the days.
We
right?
we even refused to play cricket with Israel in 1979.
Thank you for that. I didn't know that. I didn't know that. So that is the kind of very concrete and very sharp political positions we took as a country. Of course, the same government was causing havoc in our own country against our own people. That's a different matter. But in terms of the Palestinian question, 30, 40 years or maybe 50 years later, the same country which we said we are recognizing as a sovereign state is going through erasure. You know, in a few months' time, we won't have Palestinians in Gaza, right? It's already happening. What is Sri Lanka doing? What is Sri Lanka doing? Sri Lanka is strengthening ties with Israel. They have just sent journalists to visit Israel so they can come back and write positive articles about this, you know, whatever humanitarian operation, so-called humanitarian operation Israel is doing. They are bringing IDF soldiers into this country as under the guise of tourism, and no one is concerned that a foreign army or persons who are trained in weaponry is actually coming into the country under the guise of tourism. No one seems to be worried. And what that would do to the very, very fragile social fabric of Sri Lanka. So while this was happening, we were also speaking to other countries. We were also speaking to Malaysian people from Malaysia. They seem to be supportive of Palestine and so on. But once again, what we saw kind of lacking was this regional convergence of lawyers to speak about the fact that Palestine is being erased. And in Sri Lanka, it's often spoken about it as like a Muslim issue, Palestine, Muslim people, but it's not a religious issue. Today it would happen to Palestine, tomorrow it would happen to us. And the irony is, while this genocide was going on in Palestine, while I was saying this is a third world issue, in the free trade zone, just overnight, 1,400 workers in a garment factory lost their jobs because the brand which is found in the global north, in UK, they did not want to recognize a union in Sri Lanka. So what we should all recognize is, as citizens of the third world, we are very disposable. We are very disposable. So when Palestine is being erased, if we are not speaking about it, next and next and next, it would be us, it will be Bangladesh, it will be India. You know, it just go on, right? Nepal, it will just go on. So we need to find a counter voice or a resistance to that. And yes, there are various groups, you know, forming this kind of solidarity and coalition. But my question is, we should also have a coalition of lawyers, of legal voices, of legal academics and experts and judges to counter what is about to come. Because today it's Palestine, tomorrow it will be a climate issue, day after tomorrow it will be a debt issue, and it will go on. And we don't even exist in the eyes of the global north the way things are going. So I hope that is an inspiration we drew from our esteemed invitees in this conference. And I hope moving forward, we can actually take that idea forward to form a regional coalition of legal professionals, whether it be lawyers, judges, academics, activists, and so on, legal professionals, to form a resistance, a third world resistance to what is to come in the coming days, in fact. Thank you.
Thank you, Swastika. Now we'd like to invite Suren to do his presentation.
Good afternoon, audience, our esteemed foreign panel. And first I would like to thank you, Mr. Lakshandaya, Senior Counsel, and the Human Rights Committee of the Bar Association for providing me this opportunity. So I would like to talk about certain things that related to yesterday topics as well. Now there are a lot of law students here and maybe listening later to these discussions in YouTube. So when I was a law student, that is in 2010, just after my bar exams in 2010, I wanted to become a human rights lawyer. So I wanted to do my apprenticeship under human rights lawyer. But at that time, I didn't know any human rights lawyer to do my apprenticeship. So there were like civil lawyers, criminal lawyers, commercial lawyers, constitutional lawyers, all these lawyers, but human rights lawyers I couldn't find. So the very reason that I wanted to become a human rights lawyer is the situation in the country at that time in 2010-11. Just after the war, I saw a lot of inequalities in the society, and there were inequalities very closer to me. In 2011, our then president's son also gave oaths in that same batch. So there were a lot of inequalities I saw in the society. Then I had some strong ideas about the social justice. So I wanted to fight against this. So, but when I wanted to find human rights law, like I didn't know the meaning of human rights law at that time as a student. Then I did my apprenticeship under civil lawyer. I never thought like that will also be a really help as a human rights lawyer. Then in 2012, I decided to move to Kandy to work in human rights organization, where I had to do, so I kind of working in a human rights organization, but I had to do like all type of work. It is not human rights, but civil, like sometimes labor, criminal work, and sometimes I'm coming to Colombo to work on fundamental rights cases with various lawyers. So the people who came to that office, they had problems, but we cannot address these problems using by going to one court. Probably there are, like, I can go to magistrate court, but I can see that there are certain issues that I have to take to probably Supreme Court or another court for another forum. Then I was working with such lawyers like civil, criminal, and all these lawyers. So now after almost 14 years, probably 13 years, I thought of do something with the experience that I got, not only in Sri Lanka, in other countries as well. So I went to other countries for my education and various workshops and worked with many human rights lawyers in other countries. So, so I thought of having something that if a victim of a human rights violation, if a human rights violation comes to me, then I should have capacity to work with in several forums, in several court houses, like it can be Supreme Court, it can be a fundamental rights case, it can be a civil case, damages case. So there can be various remedies for these clients. So that is something that usually doesn't come to a mind of a lawyer who only work in one court. Then that is the background of that. So I think now there are, like at that time I didn't know Mr. Lakshandaya, senior counsel. I could have go to him. Then yesterday we talked about pro bono work and human rights lawyering. So I see there's a slight difference in these two. Pro bono is very important in the legal profession and to the society. It is also a part of human rights lawyering as far as I see. But when it comes to human rights lawyering, I see like many other aspects as well. So when we think about pro bono cases, like in magistrate courts, like if wrongful prosecution, like malicious prosecution, wrongful conviction, all these cases nobody take up. Legal aid commission or like pro bono lawyer will not take up a case of a thief. but there are a lot of such cases in the magistrate courts. And even when it comes to like Supreme Court cases, like fundamental rights cases, lawyers practice in Supreme Court can take up cases, but then if it is pro bono, like there are like several lakhs for the documentation, right? So this amount we have to find from somewhere, otherwise we are very limited. We can do only few pro bono cases. So my thinking is like we probably we cannot address this only through pro bono. So then I think a human rights lawyer should be able to address some issues that I talked about. So before going to the next point, I want to mention that there are misconceptions about human rights lawyering. When I came to Colombo, like I came from Kurunegala, so I not much fluent in English as well when I came here. So like mostly people think, like law students think like only posh people, elite people in the society can do human rights work or work in this thing. But I don't think so. If anybody who can communicate in English, you can learn to communicate English in English in a different stage. You can go to any forum. And human rights, the second thing is human rights is not only in Supreme Court. Mostly people meet these problems in the magistrate courts and police and other places. Supreme Court can do a lot of things, but other courts have a lot of role in that, and these violations happen in like very remote areas. So in many police stations, many magistrate courts, there are a lot of work. So English is not essential for those work. So any lawyer can work on these things. So when it comes to strategies, as I told you, like working in several forums, like probably there are instances like in the magistrate court, if the magistrate gives an order that we are not agree with, then we should have that capacity to appeal it to other courts, file revision applications to other courts, higher courts. So if we do not have that capacity, then we have to stop in the magistrate court. So this capacity to revise these orders and go to other forums is very important strategy as a human rights lawyer, as far as I see. Then there are different other forums as well. We often go to police stations and Human Rights Commission and Right to Information Commission and Victim Protection Authority. We have to work for one case, we have to work with all these institutions plus other courts. As an example, like I will not say the exact courthouse, but it is remote court, far away from Matale as well. There is one case we are doing that is on extrajudicial killing. In the broad daylight, like 2 police officers has shot one person, he has died. But there was no even a B report for that thing. That this is very common as per my knowledge. Like if police kill someone, then it is very unlikely there will be a murder case in Sri Lanka. So even in this case, there was no B report even. The police has filed an A report. It is something to like inform the magistrate that there is a death. But then we had to fight a lot to let the police to file a B report. So after like 2.5 years now, after non-summary inquiry, now it is pending. Then we had to file like 1 writ application for that, 1 fundamental rights case, and we have filed a civil case for damages, and we have filed right to information applications, and we have filed like we have complained to Victim Protection Authority because the police, they were like continuously harassing this family because of these complaints and cases. And so we have to work with all these forums, and we have to work as teams. Like, we have to team up with other lawyers. Even this case was sent to us by a lawyer in that particular magistrate court, because she was finding it difficult to challenge the police and do all this. And in this particular case, like, the police legal division, from the police legal division, lawyers came to that remote court with several vehicles from Colombo, like spending public money. It's almost like defending that police officer who shot. So even I had to complain against that police officers to the Supreme Court, and I complained to the Bar Association as well. This very common phenomenon, like police going to various magistrate courts to not to prosecute, but to kind of, that role should be independent. They are in the death inquiry, they are just leading witnesses. That's all, that is on their part. But there are issues with that. Then UN mechanisms, like we had last year also, we had a training for young lawyers on UN mechanisms, so how to use UN mechanisms in our cases. So there are many such instances, like we file individual complaints and complaints to special rapporteurs, and now Human Rights Council sessions are going on, and there are statements being made in the Human Rights Council. I believe all these things can be used in our as strategies in our human rights lawyering. Then there is a very big problem. That is, what will happen to the victim when we are doing all these things? The victim will face a lot of threats, and most of the victims that we get, like torture victims or sometimes sexual violence or many other victims, they are like the poorest people in the society. So they face a lot of threats. So sometimes we have to relocate them, and sometimes we have to give them we have to find them financial help and medical assistance. Sometimes the legs are broken and many such injuries. Then psychological assistance. All these things are very important. So as lawyers, we should have some network to refer our clients to all these, for all this assistance. I think that is also very much needed. Otherwise, the client will not be able to continue with these cases and in these forums. Then one of the ways that I found to manage this high cost in the Supreme Court and Court of Appeal and all these forums is to combine instructing and counsel's work, especially in human rights related cases. So we sometimes try to get like funds from, there are different organizations in Sri Lanka as well. So we refer the victims to them, and we try to get those documentation charges from these organizations. And we do instructing work as well, so we can at least reduce that. And another reason for that is the junior lawyers, they can learn the counsel's work as well by working as instructing attorneys under sometimes president counsels, very senior counsels, when they get the chance to work with them. So they also learn, otherwise they will just become instructing attorneys. And apart from that, like we as human rights lawyers, we get to do advocacy and negotiation, like sometimes that is not related to legal representation, but sometimes representing communities, we have to deal with third parties. Like nowadays, something that I'm dealing with is like related to a group of people living in an estate. They don't have any houses, like proper houses. They don't have deeds, but they have lived there for 200 years. So we have to negotiate with the landowner. So these type of things, sometimes to change policies, we have to work on this, and sometimes these special determination cases and all these things. And research and awareness is also very important. I work with 2 different organizations on research and like awareness on human rights, and especially training young lawyers or students. I work with the Peradeniya University students a lot. They send for externship and internship programs. So I think that is also really important. And as I said, like last year also we had this training on UN human rights mechanism for lawyers. So I saw 4 of them here during this program. Then, as Swastika mentioned, like if you are a human rights lawyer, then you are a human rights defender as well. So working on cross-border issues like refugees, or working like maybe in a protest or in other forums, like to represent these international issues like Palestine issue, all these things are very much related to a human rights lawyer. And human rights defender, in the sense like there is UN Convention on Human Rights Defendants, and there is a special report on human rights defender. So human rights defender is an umbrella term for human rights activists and many people who are working to change the world. So when you come under that umbrella term, then you get certain like kind of support from the international community. So if you become a human rights lawyer, sometimes you get support from all these things, sometimes maybe some funds to do your cases, or sometimes to relocate if you are in a threat. So it is very much important to think about that as well. Then I want to little bit talk about challenges. So human rights, as a human rights lawyer, I think if you really put yourself into this, then you have to face risks. I will mention like the 4 people like who are here. Most of them have received threats. I think Lakshanda, sir, he relocated at one point, and Swastika got arrested. Swastika got arrested just after being with me in the court. And Hijaz was arrested 20 months. Nuwan was arrested, and yeah, I was there near to his cell on that day. So there is a possible threat, and
they are getting arrested when they are with you.
Yeah, that is also a thing. So somehow I get evade. So I also have received threats in many ways. Like in some cases, like there are some clients who has fired me. So sometimes police is very really harassing. They have gone to my hometown, my mother's place, and tried to talk to me from her phone. There are many such incidents. Not yet arrested. Then not only risks, human rights lawyers get burnout due to like hearing all these traumatic things from clients. That is common to all the lawyers, but I think human rights lawyers often get caught with this. So, and if you are a human rights lawyer, then you get some support, as I said, as a human rights defender. So there are programs like rest and respite programs for human rights defenders who are at risk. So I was also in such a program last year for 3 months in Norway. And the third thing, not financially appealing. That is what Swastika also said. That is obvious. So now all my, as you can assume, all my contacts and experience are going to not to build something for me, but I'm investing it on this human rights law chamber. So this is something, it's a law firm, it's a partnership, but we are in agreement to not to make profits, but to put the profit back to the firm so we can make this big and have more lawyers. So that is something that like most of the human rights lawyers are doing. They either do pro bono work or investing these things on other clients. So yeah, so those are the things that I wanted to mention right now. Thank you.
Thank you, Suren. And I think I agree with both Suren and Swastika. Well, if you choose to be a human rights lawyer, life is not that easy. And that can be the same reason we don't have per se human rights lawyers. I mean, we cannot survive. You have to have many, I mean, you have to be happy that people are getting divorced so you can do divorce cases. You know, so many other, yeah. So that is a challenge. But in addition, Swastika, I think now we have come out with so many of challenges. But something what we have learned from these eminent lawyers and judges from the region, that there are strategies. We have to find strategies way out of this. Now, I think I met Swastika maybe 12 years ago, the first time in a magistrate court, both of us in the magistrate court. So Swastika came for a refugee matter of releasing a Palestinian and Syrian refugees, if my memory is correct. Eritrean and Syrian, or Palestinian and Eritrean refugees, and at that time she was supporting the Legal Aid Commission. So I think, as they said, maybe we have to start human rights work in the first instance court. So that's one of the thematic areas that we discuss. But in the same time, that's another reason we have included a sample draft of a petition that you can challenge in the fundamental rights case in Supreme Court. Some of you think that the fundamental rights jurisdiction or the writ jurisdiction are very kind of aloof thing. No, it's not. Every one of you can practice on that jurisdiction. You need guts. You need to learn a little bit more, and you need some support from somebody who's familiar. That's all you need, and language. But those also don't need the language every time. There are people who support in Tamil language and as well as Sinhala language. So it's what you need is you have to have commitment for human rights work, and as others said, you need to be a defender as well, and also you need not to think always the financial part of it. Let's do the address the necessity. So then sometimes you will be end of the day you will be really losing of that case, but still you must, as Hina said once, you have the satisfaction. So these are the challenges for human rights. But in the other time, as Justice Fahmy said, you need to look for new strategies, and how the Nepali Supreme Court found new way of accommodate human rights. And as well as our friends from Bangladesh and India say so. So we need to look at new strategies and move forward. If you think that one courthouse is not very conducive, you can look for different jurisdictions to reach your target. So with that note, I would like to invite, if you all have any questions, to Swastika and Suren. I mean, I see Swastika as future Hina Jilani from Sri Lanka, and Suren as someone like Justice Hari Prasad and Mr. Anik and Colin from Sri Lanka. So these are our investment. These are our future. Yes. Can you use a mic if you don't mind?
This question goes to Swastika. I am having a small problem with regard to a case. Now, once we finalize a case, conclude a case in the magistrate courts or the district court, it's very difficult for us to get the certified copies. And we have to justify here and there, and it takes long time, at least 2 or 3 weeks time to get it. Don't you think this is a challenge? And what are the strategies for this?
Yeah, we'll take one or two other questions if there are, and then Swastika and Suren both can address. And I mean, okay, maybe you can ask some of their experience if they like. I mean, they have, I mean, so much of experience to share with you, but same way you can ask questions. Young lawyers, you can ask. They're also young, not like me. Okay, Swastika, we can start with that, answer that question.
So
and then I have few questions for you all.
That's a administration of justice issue. I mean, I also struggle, and I'm sure Suren also and Lakshan also can. It's a huge struggle to simply get proceedings, and when you have to, particularly when people, like there's a case in Colombo or a case in another district, and clients come all the way just to collect the proceedings, and they say, no, it's not ready. You know, it's a huge burden on people. I think the Bar Association has been, and the Judicial Service Commission, not Judicial Service Commission, the administration of justice system has been trying to do something in terms of the Supreme Court, where they're trying to now, you know, at least in terms of the proceedings, they're trying to do like an online thing, so it's easier for people to access. It's an administration of justice issue, and we have to, I mean, even though it looks like a very, you know, routine, boring thing, it takes a huge cost and particularly money for people. I think we have to talk about it, and I don't have any answers for it, but we have to talk about it and find a solution. Online is a good thing, but beyond that, we have to also find a more effective system than what we have now. Thank you. Yes.
We all face that same issue. It's a very severe issue.
It's a serious problem.
And not only magistrates court, even in the district courts as well. It also same similar problem sometime, but maybe after they are working on digitalizing, from the Supreme Court to down. So things may be bit better. That's what the Minister of Justice says. Once the digitalized process is complete, things will be much better. But we have to see. I cannot speak for themselves. I would like to pause one question now. Is it only through the courts we can achieve some targets? What are the other mechanisms? Now, Suren also talked about RTI Commission. So what are the other mechanisms you come out as a strategist? Because recently I found a torture case. So the Human Rights Commission awarded 2 million for the victim. So don't you think the Human Rights Commission is a vehicle or new avenue to reach the victims, I mean compensation and the redress and the justice for the victims? And what are the other mechanisms you think we can use as a new strategies?
So two things. One is, as Lakshan said, there are official processes like the Human Rights Commission. The Human Rights Commission also has been struggling for a long time in terms of resources. I mean, when we speak to commissioners who want to do something, but they have been really struggling with resources, and every single FR violation which happens first, whether you file it in the Supreme Court or not, goes to the Human Rights Commission. And there has been moments when Human Rights Commission has given very important landmark orders, which we have used for other matters also. So Human Rights Commission is one avenue. The other avenue, which is of course my favorite mode of doing anything, is that lawyers are actually on the ground. You know, this we experienced in a more popular basis during the Aragalaya. But as I said, there are always, constantly there is some struggle happening. And when there are lawyers on the ground, I'm not saying go and capture the struggle or pretend as if you're only leading the struggle, that's not what I'm saying. What I'm saying is when lawyers are on the ground, things get easier for people, whether it be dealing with the police, whether it be dealing with the military, whether it be dealing with the STF. They take 2 steps back before they deal with a lawyer. So that is not, I think that's something which lawyers don't do enough, I feel. I mean, we have a handful of lawyers who are there in all the struggles. So that is something which I think lawyers have to get more involved in. And it's not like you're doing it out of the, bleeding heart or a goodness of your heart or anything. It's good for the practice also. So when you get involved in struggles, when a case comes to you, And when a client tells you something, it's not like as if you don't understand the language. Like for me, certain things I understand because I am part of, let's say, labor struggles. When there is a trade union strike, I understand why workers went on strike. I don't judge the strike. I don't say, oh my God, strike is happening, the country's economy is going to fall down. I know why they have gone on a strike. And I know that because I work with trade unions. So for us also to understand how the law works on the ground, for us to understand why people don't come to courts on time, for us to understand why a person who has been in prison for 2 years still choose not to, challenge the police. You need to be able to, you need to be able to understand that you have to work with the people. Another thing which doesn't happen so much, which lawyers can contribute to, is prison visits. Now, lawyers have an advantage which ordinary people don't have, is that we get to sit with the prisoner. We get access. We actually get to sit with the prisoner and talk to them and so on. So we used to do that. Now I don't do it so regularly, but as Legal Aid Commission, as with various other lawyers, we used to access prisoners, and even other lawyers would refer cases to us just to go on a Sunday and speak to prisoners. And when you do that, you find cases where people have been in detention for 5 to 10 years or so on, and then we are able to advocate for those cases. A classic example is the case of the political prisoners who are in prison. They have been in prison for over 10 years under the Prevention of Terrorism Act, and not many people speak about it. There are a few Tamil and Muslim lawyers who speak about it, and lawyers like Suren and Lakshan who have been speaking about it for ages. But political prisoners is an issue where they have been in prison for over 10 years. So why aren't they not getting a presidential pardon? Why aren't they coming out of prison? So how would you know about it unless you go into prison? So these are things I think which lawyers can do about. This is not only for the community, but also for our own understanding of the law. So when you rise up in the profession, when you become a president's counsel, or when you become the attorney general or the chief justice of the Supreme Court or whatever, we are not like removed from society, sitting in an ivory tower looking at society and then saying, I don't know why this is not working. I don't know why people are not coming to court. There is an obvious reason for that. So it's good for us also to be part of struggles. Thank you.
I think I already answered something.
Okay, maybe we can go for 1 or 2 questions maximum, and then we can wind up. Okay, there's one question from. You want to ask a question there, or? Okay, after that you can ask it. Yes.
Actually, I want to ask few questions. One is, how do you balance personal risk with public advocacy in high-stakes activism? And other is, what can civil society do when the legal system itself become a barrier to human right protection? And final thing is, what message would you like to give young lawyers entering the human rights field today?
Thank you. And shall we take the other questions as well, so then but both Swastika and Suren can answer that question.
I would like to ask, with your experience, what are the key skills that a human rights lawyer must master to be more effective in their work? Thank you.
From Medha, I think. Okay. Okay. 1, 2, we'll come down. Medha and then Justice Fahmy. You also asked a question, though. Sorry.
I have a quick question, since you also made the reference about PTA. My question is, I'll try to articulate as clearly as I can. So recently there has been very high-profile political arrests that were happening, and there were a lot of back and forth regarding arresting somebody on a Friday, right? But then again, regarding the arrests that were happening on a Friday, there has been a principled position that was articulated by the human rights lawyers that it shouldn't happen on a Friday, because then it leads to, like, this is not right? Basically unethical in a way. Although it can be justified in law, but it's not the right thing to do. So my question is, when there are extreme options, and also when there are strong opinions against people, especially against the very human right violators who has used the PTA, As a human rights lawyer, how do we take a principled stand? Are we expected to take a principled stand right throughout that any arrest on a Friday shouldn't be justified? Or like, how do we draw the line there? I know it's a gray area for sure, but how do we draw the line there? So.
And then Meda, and then Justice Fahmy. And with that questions, we will wind up.
My question is to all three of you, because I consider all three of you as pioneers in human rights law and advocacy, and I'm personally very proud of all three of you being on a friend basis and also as a colleague basis. So the question is that how is the reception, not the support, how is the reception that you get from the other colleagues, from the other learned friends who are not involved in human rights per se? I'm not saying not involved, but not as deeply involved as you are. And that's one section. And also from the judiciary and also from other, say the ministry or the department, perception. I'm not talking about the support. Are you looked up to? Are you looked down upon? Are you looked at with contempt or as a troublemaker, or what exactly it is? Thank you.
And Justice Fahmy.
Don't worry about it. I don't want to ask the question, but I would like to share some experience after the questions are answered in relation to sexual harassment by judges, and an experience which could probably give you a strategy and a way to work around that.
Thank you, Justice Fahmy. I think we have a film done by one of the famous Sri Lankan film, The Court is Silent, and that is also a sexual harassment of it in the courthouse. I would like to invite Swastika and Suren, and then
I will ask answer some of the questions. Like, the first question is about managing the risk. So as a human rights defender, you should, like, the lawyers, or that can be a journalist or a human rights lawyer or anybody, human rights defender, you should know the space that, the amount that you can work. If you exceed, there is a possibility, a threat to your life. So you, like, with our, like, probably the social acceptance or our education and social recognition, with all these, like, each of us get some civil power, right? So there are things that you can do and there are things that you cannot do. If you do certain things, if you go to certain level, then your life is at risk, and there can be issues. So that is why I told you then there are options, like you have to relocate to somewhere else and you have to come back to your work. So you should know the space that you can work. Otherwise, it's quite difficult, right? If you had to go to another country or, like, save your life, then yeah, there is a problem. So that is my idea about that. Then I would say one skill to become a human rights lawyer, that is empathy. You should feel the client or the victim, or if you feel that, and if you get angry. So usually in our society people say getting, like, angry is not good, right? But if you don't have anger, then you will not fight for something. So you should feel empathy, and you should feel the victim, and about that social justice issue or something, that you should get angry. Then only you can do this. Then reception of lawyers, like how the lawyers and the judges, or sometimes the department, they look at us, that really depends on the person. I have received a lot of comments, like, I used to appear in cases under Prevention of Terrorism Act in Kandy courts for several years, first with the senior and then by myself. So he's a Tamil lawyer. So both of us got comments, like, we were kind of called like LTT lawyers. So that is, the ward is LTT ward, and the suspects are LTT suspects, and the lawyers are also LTT lawyers. So, and everyone looked me as a Tamil, though I'm Sinhala. And there are, in certain courts, sometimes my colleagues even have asked me why you appear for in these cases. If someone gives you money, you appear for anything, right? Things like, comments like that I have received. But there are good comments and good reception in many places as well. And sometimes people say like, you get funds and you like NGO, that word, right? That is how you live by this. So there are such comments as well, but good comments too.
Personal risk, I actually don't know. One thing is, this is what I tell like the younger human rights lawyers, is that in human rights field and activism, you always, I'm willing to die to, for the, and I'm saying, no, you don't have to, that's not, we're not going to, we're not trying to die, that's not what we're trying to do. So I think prioritizing personal safety is important, and if you're getting threats and so on, you're not being brave by handling it alone. One of the ways we handle risk is we work together with people. So the more people we work together, the more support and the less risk we have. And Suren and Lakshan were saying sometimes lawyers had to relocate until it was safe to come back. So there is nothing brave about being alone and facing threats alone. I don't agree with that. You have to be together. And you also, as a human rights lawyer, you also have to extend when your friend is going through a threat. For instance, when Hijaz was arrested under the PTA, how many lawyers were willing to speak in support of him, knowing very well this was a false arrest? So that is also, you also have to stand in solidarity if you want to get solidarity back also. So human rights is also an act of solidarity for people who are defending human rights. So that is one of the ways in which you can, counter some of the threats. There is always threats, as Suren was saying, Suren was threatened because he did certain cases and so on. So there is, you can't, it's not a risk-proof job, but there are ways in which you can protect yourself in some instances. I think you asked about the legal system. Legal system, I always say this, and it took me a while to realize this, legal systems are not drafted or not structured for socially vulnerable people. It's not drafted to, or it's not structured to serve women. It's not structured to serve people from minority communities, at least in many countries in the third world. So inherently, legal systems are not structured to serve the poor. Now, if you actually think about a legal profession, like we have free health, we have free medicine, but we don't have a universal legal assistance program. Why should a person pay money to receive justice? Our justice is contingent upon how much money we can pay, and that itself should, we should pause there and think. So legal system in itself is not structured to serve the vulnerable, I would say. So we have to consistently fight. And one of the fights which I think I and Lakshan and Suren used, we don't do that so actively anymore right now, is to push the legal aid system, to make it more wide. As Suren was saying, legal aid doesn't appear in criminal cases, but that is one of the area where people get affected the most, but legal aid doesn't go there. So we are always pushing for more budgetary allocation for the Legal Aid Commission, to widen its ambit. And that does not mean we are trying to, take away the money of private lawyers or anything like that. It's just that, we need to have a better legal access system. So that is some of the ways in which you can fight for a legal system which is more inclusive, which is able to cater to justice for many other people. I agree with Suren that you need to have empathy and so on. In addition to that, I would also like to say, learn your criminal law, learn your civil law, because only if you know what is in the law, what is in the practice and how it happens, you will be able to make it more human rights friendly. If you don't know what is in the system, you won't be able to counter that. So technicalities, in addition to empathy, technical skill is also very important. That is, very, very important, technical skills, because on the other side, you have the Attorney General, you have the criminal lawyer who knows what he's doing, the police who know what they are doing. So if you want to counter that, you need to have technical expertise. In terms of, before I go to the Friday arrest, which I took a very clear position on that, but before we go to that, in terms of reception, I'll just try to add to what Suren said. I do a lot of domestic violence cases, and I always tell this to my legal colleagues. When you do commercial cases or when you do bank cases, no one comes and sits down next to you and wastes 1 hour of your time telling you that, do you know about that client, how much money he has stolen, how many microfinance victims have died. No one advises the banking lawyer on the fact that he should not be appearing for the victim. It is only when you do domestic violence cases. I've had lawyers sitting next to me for nearly 1 hour defaming my client, saying that, do you know what she has done? You know what she has done. You know what she has done to her husband. She wants some money from her. I don't go and advise my learned friends on how to do banking cases when they are doing banking cases on behalf of banks who are bankrupting people. So I always, it's interesting, right? And as Suren said, most often, you get very positive comments. Judiciary is particularly magistrates are very appreciative of lawyers who take up pro bono cases because, otherwise it's just coming on to them and there is no lawyers handling the cases. So particularly magistrates and courts of first instance are very appreciative of lawyers who are doing pro bono cases. Lawyers are very appreciative of, and because more and more lawyers come into doing these pro bono cases, the burden also eases on all of us. So we are also we also kind of, we're like kindred spirits, we appreciate each other. But there are these certain, you get unwanted advice from people, particularly when you go to handle rights issues like women's rights, minority rights, and so on. People find the need to come and advise you on the fact that, how they are defrauding the system or whatever. So I had that quite a bit in domestic violence cases, when I handled domestic violence cases. On this Friday issue, so let's break it down because, so recently our Prime Minister got arrested former Prime Minister he's there in politics forever, so he might come as a Prime Minister again. He got arrested, and the tag Friday arrest came about because what the police does, and usually it happens to people who are more vulnerable, is that what the police does is they pin cases where it's not easy to get bail, and they bring them to court on Friday. So the magistrate doesn't have enough time to decide on whether to grant bail or not. The police will make some application. If it's a protest case, the police will make an application saying that we need to have an identification parade and so on. So bail is not granted. So on Saturday and Sunday, they have to go into prison. And Sri Lankan prisons, I think like most South Asian prisons, is not a nice place where you want to be in. So these Friday cases, this tag started in saying that if you want to keep a person at least in 2 days in prison, then you bring that person to court on a Friday. So the magistrate is also kind of like, what do I do now? And so the person is kept in prison for 2 days. This particular instance of the former Prime Minister, I of course took the position, it doesn't matter. The reason is, this is only my extremely personal opinion. I don't believe our system is not, fair and unbiased and just, right? There are people who, the clients we represent, they never get a fair hearing. They don't even get a time to go, they don't even get a chance to go to court to fight the case because of people like our previous Prime Minister. So if he is produced on a Friday with all his resources, if it is all his lawyers, if he is produced on a Friday and kept in prison and he never stayed in prison, by the way, he ended up in the prison hospital where he had a chilled out, not even government hospital where he had a very chilled out time, and then he came out with Boris Johnson's book. So if a guy who is like extremely privileged like that, if some police officers and some public officials are trying to make a desperate attempt at a show of justice, then I don't see a problem with that, because we always say this: justice should not only be done, it should also be seen. Like, you should also show people that justice is being done, because otherwise people lose faith in the system. So on that basis, I took the position. And why did so many, Prime Minister has money to hire lawyers, why did so many lawyers, pay for him? That's their freedom of whatever they want to do, but I just, it was curious, right? So for me, a person who, this is the bottom line for me. A person who ran a torture camp, was responsible for illegal disappearances and deaths and, torture. he was produced on a Friday for a completely little irrelevant, very insignificant thing like misuse of public funds, and he was supposed to be kept in prison for 2 days. I don't find the need why we as human rights lawyers need to, we don't have to take a position. We can remain, no, the world is not looking at us and saying, oh, what is your, we are not that important. So we could have remained silent, right? So, but there are things which we have to be vocal. When, for instance, when Mr. Hizbullah was arrested, we should have been vocal as a legal profession, and we did not do that. When Nuwan Bopage was arrested, there were few lawyers standing with him, like Suren and Lakshan, and, I am not naming many, but, there were few. When Lakshan was threatened by the justice minister, how many lawyers spoke for him? So there are things which we have to be vocal, because, the noise is not enough. But there are things which we don't have to take position on, because we are not that important. And this arrest, the former Prime Minister's arrest, is one of those things where I was very happy and I didn't say anything about it. Thank you.
Yeah, before I go for Justice Fahmy, I would like to say a few things, bit of advertisements. All of those who are like to work on human rights, you are seriously welcome to the Human Rights Committee of the Bar Association from now. So please send your text messages to Swastika or me. I'm the chair and she's the convener, or even Dharmika. We will welcome you happily. That's number one. Why? Because we need more hands. When you go for human rights work, you need each other's support. You need to talk to each other. You need to ask, okay, this is something going to happen. What do you think about it? So then you need, maybe I will join with you to go to these particular courts. That's what you need. Secondly, very personal note, when Meda asked, how about other colleagues of mine thinks, I don't care about it. If I'm going for some target for the human rights, I have come out of a situation where the entire bar of that particular the courthouse is against me and I'm alone. No, I don't care about it. I am shouting as far as possible, deep throat of mine, and say what I want to say on behalf of my client. That's all. That's all. So, and that is our second thing, and I want to share. And then thirdly, we human rights lawyers, we cannot segregate. We cannot have double standards. If you are a human rights lawyer, you are human rights for minority rights, sexual rights, domestic violence, environmental rights, gay and lesbian rights, everything. I see sometimes now our human rights, well, I am okay for minority rights, but not for the gay and lesbian. I can't. Oh, I'm very happy with environmental, but I don't like to work for Tamil people. I'm okay to work for Tamil people, but I'm very scared of Muslims. That cannot be done. We are human rights lawyers for all. You cannot select or choose your client. That's all I have to say. And now I owe to Justice Fahmy. I think we better arrange a mic to, yes. Okay. Yes.
Along with my comment.
Amidu, can we stop the live streaming from now?
Oh, it's live streaming?
Yeah.
Good heavens. I was about